Criminal appeal is allowed. The criminal revision is dismissed.
Item 3.
Allowed.
Item 4.
Right. Proceedings are passed and with some certain observations.
Item 5.
Allowed.
May I say my name may come reflected mirror, sir. I have given from time to time I have been appearing. Name is missing.
The problem, I'll tell you, the problem here is if the senior counsel name is there, the briefing counsel name is not there. Actually, senior counsel name, simple sitter can't go.
Actually,
He has to be briefed by someone.
our name always is coupled by
And generally, senior counsel names are there and the briefing counsel name is not there. I have seen in many cases. Yes. Who?
Item 6.
Jashwant Singh. So I have made some observation. It is partly allowed. The same here. I have partly allowed with some observation in view of the recent circular.
Item 7.
It's dismissed.
Item 8.
It's dismissed.
Item 9.
Dismissed with liberty.
10.
10 minutes. I have allowed the petition with remitting back to the court below and with the time bound direction. Time bound direction.
11.
This I have allowed by taking note of the recent circular by carving out a exception that this is a case of called pandemic period. So therefore, I have allowed it, and I cut off the difference.
Pardon to make a mention, my lord.
Last occasion, your lordship may had this matter on last Thursday, 19/12/2024.
Yes.
As the charge sheet copy was not available in your lordship's file, but it was very much available in flag A in hard copy. But unfortunately, the student is suffering, and I have.
What do you want?
Tomorrow, my lord. Tomorrow, at least your disposal.
Tomorrow, tomorrow.
I know that.
Largely, it will not be.
ପିଲାଟି ପାଠ ପଢି ପାରୁନି କଲେଜ
Tomorrow.
Parents must-
It's all right.
Order of NBW has
It
been
happens,
issued.
happens, it doesn't happen.
Order of NBW has been issued and this honorable court stayed the order of NBW with a direction to surrender. In pursuance of the order passed by this honorable court, I was deposited the amount before the trial court and surrendered.
What do you want?
The petitioner are in custody. After their surrender, your lordship may kindly see, I have annexed the order.
I have said that you resort to the remedy available to you under law. You have to move bail application.
My lord, that was rejected. Your lordship may kindly
Then
see.
what can I do? Then you challenge that order.
In
You have asked for a NBW cancellation.
NBW was
I have
recalled.
set aside, I asked you to go and appear and resort to the remedy available to
My
you.
lord, I have already appeared.
Then rejected the bail, then.
No, my lord, the petitioners are on bail.
Ah.
NBW order was set aside by this court, which is subject to payment of 500. Thereafter, they appeared before the learned court below.
Ideally, you should have been, because you were already in bail. So
No.
ideally, you should have been released on bail.
Your lordship,
Not be,
your lordship may kindly see the last order of the trial court. Your lordship may kindly see. Last but one page.
Yes.
NBW was recalled, but the petitioners are in due custody.
What are the offences?
294, 506, 3 SST.
Ideally, you should have been, because you were already on bail.
My lord,
So for one default, NBW was issued.
my lord,
I set aside. I told you to go and appear
my lord.
and resort to the remedy. Then the trial court should have given.
That-
I'm with you.
I have filed in this case today. The lordship may pass an order. In the meantime, the learned court.
Put it tomorrow.
Lordship, pursuant to
This
last,
this is the communication. That is how the burden of this court is increased.
And what if the apathy of that lawyer who is conducting a
He has come.
I understand. Definitely.
Lordship, pursuant to,
These things has to be dealt with in that side also.
Lordship, pursuant to last order, both the party are physically present.
Henceforth, what I'll do is, I'll make an observation there also.
Yes.
That's the better thing. I'll have, needless to say that the petition was in
One-
something,
one-
something of that sort, one line, so that this trouble will not.
My lord, today.
Today is not possible. 200 matters.
Lordship, pursuant to last order, both the party are physically present today, but matter is not listed. They have come from Raigad.
First week.
They have,
First week. Today is not possible. 100.
they have come from
Let
Raigad.
them come once again. They'll come. What is the problem? They let them see the High Court building. And go. Have the coffee and all. You treat them for coffee and all.
Any fixed date.
He'll give it.
It is the matter you also may recall that person was carried to the court in ambulance.
What happened?
But the court has already disposed of the interim bail. So only one line will,
No, I have granted interim bail,
not interim bail.
but I have made some observation.
The observation is that he can renew, he can move his interim application which is pending. In fact, that's not pending. That's not.
Already, you said it is pending.
Well, I have checked my lord, later on, he rejected since long. It was
You said pending, I wrote.
my lord, extended from time to time. Up to 31st, your lordship has given me and he is now still at Raipur.
Kal dekho, kal lagao.
I'm permitted to make mention, my lord, one CRLMC 4704/2024, my lord, fresh admission matter, my lord. Here in the case, the present person challenged the quashing of the criminal proceeding, my lord, and the FR was lost, my lord, 302 and 34 IPs, my lord. Charge sheet filed,
What do you want, madam? You have argued the full matter.
charge sheet filed, my lord, against absconding charge sheet, my lord, and the all co-accused
What do you want? What do you want?
This matter taken from all co-accused person already facing the trial and he is already
First week.
acquitted, my lord.
I'll take it up in first week. First,
Tomorrow.
reopening date. Reopening.
Another matter is same, my lord, 1307 and 34.
Reopening date. Reopening.
Tomorrow, my-
The senior is waiting. Wait.
Police officers matter that between two officers, 376 allegations.
Yes.
The other side, I was told he did not appear. He was supposed to do, the informant was supposed to make his submission.
Last time. Yes.
He probably chose not to appear on the last day. My only request is that you have finished. If he doesn't also appear today, same thing. Should I make it close it?
I think he may come today. Specifically, this. Yes.
And what is already there?
Yes. Yes, that is the matter that police officer from 376
That.
and all.
Pardon to make a mention, my lord. Pardon to make a mention.
14, my lord. I humbly pray, my lord, it can be taken up after vacation also. Last
Okay.
I
This prayer is readily accepted. This one, 104.
My lord, pardon to make a mention. My lord, one CRLMC number 2801 of 24. My lord, it was specifically adjourned to 23 October. My lord has granted interim order for 8 weeks. My lord, that has already been expired. My lord, the next date is posted for 6th January in lower court. My lord, he may warrant may kindly be will be issued against him if
6th, before 6th day,
days.
before 6th.
Order to make a item number
1 minute, 1 minute, 1 minute.
109.
Any other mentioning here?
109.
Page wise I'll call.
Ma'am.
Page wise. Page wise I'll call. I have miscellaneous mentioning, you please tell me.
No mention.
Miscellaneous mentioning? No. Okay. Page wise.
Page 2, item 12 to 16.
Item 18 and 19, Your Lordship. I prefer after vacation, Your Lordship.
1 minute, madam, 1 minute. 16. Anybody that in 16? Yeah, yes.
17 to 24.
Yes, 1 minute.
23.
17. Yes, what do you want? Oh, vacation. March.
23.
And
Item 18 and 19, Your Lordship.
19 and
18 and 19.
18, 19. Urgent. Okay.
Item number 23.
1 minute, sir. Page wise. I am calling page wise. Wait.
Item number 23.
23. 43 is it, 23. 23. Okay. Okay.
After vacation.
Okay. 23 after. Yes.
25 to 37. 38 to 52. 53 to 66. 67 to 76.
I pray my lord 72, madam. I pray my lord after vacation.
72. Okay.
77 to 81. 82 to 85.
Item 85, you see, by matter relating to well, I have applied in the meantime some appeals have been examined. I have applied the copy of the deposition, shorter adjournment also.
Second week. Take.
86 to 92. 93 to 99. 100 to 105.
Malad 100. Compromise matter, both are present.
I'll take it up 2 o'clock. What are the offenses? It's all right. Foxo is not there.
No, post.
12 o'clock? 2 o'clock? 2 o'clock you want?
12 o'clock.
2 o'clock or what? 12 o'clock? When do you want? 12 o'clock you try, huh? If it doesn't happen, then 2 o'clock. Yes.
106 to 113.
109, Your Lordship.
109.
After vacation.
Yes.
108. I am for opposite, but I have actually kindly taken out after vacation.
108.
I am for opposite.
Now you have you informed the other side? That's the problem. They will see, the other side will come and see that mediation failed. Further.
Lordship, item number 111 may be urgent to.
1 minute. 108 is urgent. 109 also you want adjournment. Yes. Then
111, you know.
11.
Lordship, interim order to continue.
Who is the other side?
I am appearing on behalf of.
No problem.
No, my lord.
Okay.
Interim order may continue.
Yes.
And date, my lord.
Date he will give. Wait.
Oh, bless me.
115 to 121.
114 टा मुको इपरले जागे.
हाँ.
114 टा after.
114 stayed out as 130 denied material. Last time my lawyer has taken time. There is proceeding has been stayed before the.
And who is the other side?
So move अच्छी petition.
130 matter I am appealing for the complaint.
आपण जेते छुट्टी पर जो दिन रखन तो कर दे.
138 matter. First of all, there should be any stay.
I am mentally ill, my lord.
The last date my father's ground के time नहीं I am not disputing on that day. Judgment.
See, you have taken June 2016. You have 24. You have taken. 3 dates you have taken.
Again.
Lordship reopening रासु है.
Reopening.
हाँ reopening date रख.
3 4 रख दिया. 4 कर दे. 3 रख दिया. 138 generally.
हाँ कर दे. Yes.
Okay.
122 to 130.
126.
126.
Parties are present.
Offense.
That is, POXO is there, but they have all deposed before the court. That is deposition before the court.
In their favor.
Yes, ma'am.
then the court will acquit you.
Okay, that's why your lordship has directed let the party, affidavit has already been filed, both are present. It's possible, my lord, otherwise.
Well, then, 12 o'clock we'll see.
Yes, sir.
I will get the deposition copies.
Yes, my lord, that I have annexed. That I have annexed already.
Yes.
Item number 129.
29. Yes, sir.
Mr. P.P. Sankar, your six had hardly got a last condition. Both of them have submitted, they have lordship directed to submit the written note. The father is expected to make a mention whether it's
After vacation.
3 or 3:30, if the lordship know.
No, today don't. I will not take the burden, vacation burden. I will not take further.
No, no, I'm not saying.
And
If possible.
you want, I'll put it immediately after vacation. Immediately. Third, fourth कभी दे दी. Adjournment.
Adjournment.
No, I can't, because see, I can't take the further burden. Last day, if I'll reserve the judgment, then you know what happens. Very difficult. Is not possible. Why should I unnecessary? I'll put it in the third or fourth. Third.
Sixth.
Third and no, reopening is the second.
Even second.
Second and third. Put it in second. Okay. Third we repeat.
Sixth Monday.
Sixth. Okay. Sixth. Yes. No one.
Item 12.
Yes. Yes. Nobody there?
Nobody is there.
What is the prayer?
Criminal proceeding, 3 POXO is there, 376 2N, 376.
Quashing.
My
Non-appeals for the petitioner in the interest of justice. March.
Item 30.
Yes.
Only 363 in the charge sheet.
Huh?
Record has not come. Charge sheet.
Item 12.
12 I adjourn it.
376 POXO.
One submission in that
Yes.
manner. As because the on the date of occurrence when the petitioner was minor, but wrongly the investigation agency submitted charge sheet reflecting that the petitioner was aged about 19 years. For that reason, my only prayer is that the Leonard Court below, the Leonard Court below declare him as juvenile matter.
That has to be examined, that has to be tested.
जेहेतु चार्जशीट during filing charge sheet, they had shown the petitioner was aged about 19 years. But the annexure 5, the school certificate of
You move application before trial court. Let the trial court decide it.
that observation. That is annexure 6.
Petitioner is seeking quashing of the. You are seeking for quashing, huh?
No, quashing, but I am seeking quashing, and I'm seeking further seeking direction. Doing the petition is on the date of occurrence minor and
Page 18.
Was the criminal proceeding thereof. The criminal proceeding initiated against him in connection with Muniguda PS case number 174 of 2023 for alleged commission of offences punishable under section 376 2N, 376 3, 294, 323, 506, 34 IPC, read with section 6 of POXO Act. Land Council for the petitioner is relying upon the school living certificate.
School living certificate, annexure 5 years.
Annexure school living certificate for the petitioner, which indicates that his date of birth is
25 February 2026.
25/2/2006. And he has also relied upon the medical examination. What is this? What have you relied? This is the only thing.
Only thing, madam.
He has also relied upon and submits that At the time of commission of offence, the petitioner was a
Minor.
Petitioner was a minor. Therefore, he seeks indulgence of this court for quashing of the criminal prosecution against him. I am not inclined to entertain this petition at this stage, as the charge sheet has already been filed, and the trial court is seized of the matter. Therefore, however, liberty is granted to the petitioner to move appropriate application before the trial court in this regard, and if such application is moved, it shall be considered on its own merit. Yes.
Oblige your lordship.
Yes. 13. None appears in the interception. Yes.
14.
May I please your lordship?
Yes.
Lordship, may I recapitulate. Actually, the petitioner has filed several five criminal proceedings which are quashing for OPID Act. During that, the petitioner is already in the custody more than 7 years.
OPID.
So the OPID under section 10. Section
OPID.
So the lordship has directed that a convenience charge should be filed, making all the criminal.
Let us see. Let the OPID council come. Pass over. Huh? Pass over. I know. Remember, you have already remained there for more than 7 years and all these things, and you are not able to pay the
because of security. Cash security.
Cash security are not able to arrange. Yes.
15.
15, my lord. 15, lordship. Your lordship question. Your lordship is directed to obtain instruction because Priyanka Sonapati, he has not filed the affidavit. So it is a arising of the complaint case. So my humble submission, lordship, is that there should be notice should be issued to the informant.
Notice was issued. Notice. Notice to opposite party.
Number 2, man.
Number 2, huh? Is notice opposite. Returnable. After 2 weeks. Yes. Next.
16.
Please your loss. Case under section 13(2), reduce section 13(1)(e) of the PC Act. Your charge sheet was submitted showing that 117% is the DA amount.
Yes.
And I filed an application before the learned court below saying that the properties which are shown to be on the asset sides of the petitioner has already been sold either prior to the check period or during the check period. That the investigators have not taken into account but have added to the asset list. Second ground is that the father's house, which was shown to be the property of the petitioner, has been directed by the Honorable Court to be struck off from the asset side, and that has been done. But what they have done, all the affixes and assets in the house, those have been added to the assets of the petitioner. One, the house is directed to be taken out of the purview of investigation. How can they add those? These are the 2 grounds. Paragraph 17, that's why lordship had directed my friend to obtain instruction on that score only.
Huh? File reply. File reply. Let Mr. Mahana seeks one more opportunity to file a reply to the petition. Please the matter. Yes.
Only that 2 points only. I don't want any elaborate because it's not needed. My paragraph 17, my friend reply notes, that will suffice. Only paragraph 17.
How many accused are there in this case?
No, one accused, DA case. He's an employee, DA case.
So observing that the petitioner has to explain to me. Now yes, coming.
Then how can you go beyond my observation?
No, your lordship has when that the husband, the petitioner has to explain.
He is the petitioner.
He is the petitioner.
Therefore, I have to stand by my observation. He has to prove it. I can't quash it.
No. That is not your lordship's observation. That I have to prove it. Milord's wife was made an accused, saying that under 109 Milords.
I quash it.
You also said that it's a general observation because she cannot be held liable. Here the question is, the house which was sold.
If I have made the observation, it has to be proved by the husband. Then you have to.
No, that is not. That is not the observation.
Show me that order. Show me my order.
And that is not the observation. They prove it, Milord, because it's a case of.
So where is that order? If I have made some observation, I can't go beyond.
Yes, Milord. If that will, I will remember. Here the question is the properties which have been sold to the my assets have already been sold prior to the lodging of the FIR.
That is a different story. That is a different story.
So wife's
But he says that the wife's petition was allowed by me, making an observation that it is the husband who has to prove all this thing in the trial. If that I have said, perhaps I can't go beyond.
Because wife was mainly accused because some properties were there in her name. But question is the father's property was not directed to be taken out of investigation. So once father's property goes 45 lakhs, then the assets therein and affixers, how can those be my properties? That is my case. It's no way related to wife. Whether wife gets absorbed or not, that is a different aspect.
Or the father's
yes. Again, concession, it says to be.
It needs hearing then. You file reply then. We'll see. Yes.
Concession Bapanare record a concession it's bound by law.
Mr. Samantara, when you change the side, then your vigors are very.
No, cash situation there was understanding that we will be parking our vehicle there and we will be accommodated by way of a vehicle. But today there is so much of cash. Most of
we wanted to try this system.
No, it's good. Don't say that.
2 years it has to be closed.
No, it is good, but arrangement we have to be there is an understanding that we will be got from there.
Whatever problems are there today, we identify those problems, and in the reopening day, we'll.
Only question is we should be transported from that place to this place.
Vehicles are getting ready.
That is why not.
Vehicles are getting ready.
So some of
them vehicles and everything will be there. We are planning for that.
Yes, that is there will be no problem as well.
It will be done. It will be, yes.
So Lakshmi, may I pray Lakshmi fix it to 7th or something like that, so that. Sorry.
Yes.
Item 20.
Yes. 20.
20 your lordship's last revision directed whether confiscation proceeding has been initiated. No confiscation proceeding.
Not initiated. Then it needs hearing. If not initiated, then interim release can be done.
Assist.
Yes. The vehicle you want release, huh?
Yes, madam.
Impugn order is this. Where is that? Impugn order is? Right on. Petitioner is agreed by the order dated. Order dated 21/5/2024. Passed by additional decision sessions at Baliguda in criminal MC number 5 of 2024, whereby his application under section 457 CRPC for release of what? Release of
vehicle, madam.
Release of which vehicle?
But it is a motorcycle, my lord.
Release
The
of
ROC is at
Hero Honda motorcycle, getting number OD 19-P-4845 has been turned down. The notice was issued to the opposite party. Mr. Jena has placed on record the instruction received for instruction dated, written instruction dated 20/2024 issued by the Inspector of Central Excise Baliguda Range, which reads as it is apparent that there is no confiscation proceeding initiated as yet. Therefore, the learned counsel for the petitioner seeks an interim release of the vehicle in subject. Please the matter immediately after vacation to address an interim. Yes.
Hello.
21.
Yes.
22.
Yes, sir.
My lord, envelope of the document Mahapatra kindly pass out.
Pass out.
Huh?
What is the What is he asking?
Has not submitted the charge sheet copy, your lordship is
Huh?
directed to furnish the copy of the charge sheet.
Earlier order was there.
ଏଠି କହିଲେ ସେ ତାପରେ କହିଥିଲେ ମୋ ଅର୍ଡର ଟା
No, no. What is he asking for?
Question of criminal proceeding.
That has been filed.
He stated that
I did not have it.
Only
I thought-
that question
Then
of the
comes
proceeding, yes, yes,
seek an adjournment to file additional
My-
document.
My lord,
Release the matter. File the additional document. Yes.
my lord.
Yes, next.
54th.
See only the rejection of the 311 petition, my lord. It is in case under section 138 NI. The petitioner has filed, the petitioner here in the accused. He has filed a petition under section 311 CRPC to examine himself again, to recall the accused person for examining himself again, my lord. Because
315.
because there are some documents we have obtained from the police as well as other sources that the checkbooks which he has used, that has been recovered from him.
I issue notice, let us issue notice.
And
Issue notice. Because 138, na?
yes.
Issue notice to opposite party number 2.
Copy two.
Opposite party number 2, no? Let me go.
Copy two, my lord. My lord, stay of further proceeding. If the judgment jadi ହେଇଯିବ ଲାଭ କିଛି ନାହିଁ.
138 I will not stay.
Only for that reason I am asking for, I will deposit
No
some
application. Application?
for adjournment.
Yes. And list it on third or fourth.
Third, fourth verifiବ କି ନାହିଁ notice କେ ଜାଣି.
You have to do it.
ମୁଁ କାଲି ଦେଇଦେବି।
Because 138 matter you can't
ଆଜ୍ଞା
say, no?
ମୁଁ ଚାହୁଁନି ଲିଙ୍ଗର କରିବା ପାଇଁ, ମୋର ସେଠି ସାକ୍ଷୀ ଦେଇଦେଲେ ସେ ଡକ୍ୟୁମେଣ୍ଟ ଗୁଡା ସବୁ ଲେଖିଛି କଣ କଣ ଦେବି।
I'll allow for 1 day and finish.
Yes, it's 1 day, only 1 day.
Okay. Yes.
Your lordship party adjournment
No, that adjournment petition.
ଆନନ୍ଦପୁର 7-8 ଦିନ ଲାଗିବ, 8 ଦିନ ଭିତରେ ଲାଗିବ।
25.
Release of my, I have challenged the order, my lord, wherein my application for release of my vehicle has been rejected. Confirming order or say. For release of the Baleno vehicle, or the present is the owner of the vehicle, but here the case is the vehicle is transported the elephant tusk here that comes under the Wildlife Protection Act. The 457 for release of the vehicle is not maintained within the special act.
I'll just issue notice, let's check it up. Huh? Simply issue notice. I'll issue notice. Check it up. We'll see.
After vehicle.
Yes.
What is this?
May I please, Your Worship? Lord, this is for quashing of the criminal proceeding on the basis of compromise, my lord. So let the notice be issued so that he can appear and
420 and all, huh? And comes for the petitioner, petitioner is seeking quashing of the entire criminal proceeding arising out of Athagoda PS case number 91 of 2022, pending in the court of SDGM Athagoda for alleged offences punishable under section 420, 468, 471, and 34 IPC. Then comes for the petitioner submits that the petitioner has already entered into a settlement with the informant. Issue notice to opposite party, number so and so, Mr. Mahanti accept notice for the state. Yes.
for the self-same cause of action, the civil suit has also ended in a
Whatever I have issue notice, you bring him.
stay of further proceeding.
No, how can I have 468 and all? I will not say, but you bring him. Nothing is happening now. First week, second week of the yes.
Date may be fixed.
Next.
27.
27 minor kindly pass over.
Pass over, okay.
28.
May I please, Your Worship? Stating of the quashing of the proceeding minor on the ground of compromise minor.
Mutual divorce.
What are the offences?
Mutual 498 minor. Mutual divorce.
498, 341, 294, 506, 323, 330.
498.
Yes, Your Lordship.
Right.
But the divorce has been granted in the annexure 2, Your Lordship, page 24, Your Lordship. Mutual
Petitioner is
divorce has been
seeking
granted.
quashing of the criminal prosecution arising out of so and so. Okay. On the so and so. Then comes for the petitioner submits that the dispute is arising out of a matrimonial dispute, and the petitioner number 1 and opposite party, petitioner and opposite party have already filed CP number 261 of 2023 before for dissolution of their marriage under section 13B of Hindu Marriage Act. The where is that order?
That is impugned, Your Lordship, judgment, Your Lordship. 24, Your Lordship. 4/10/2024, the date of judgment, Your Lordship. 13B.
Date on 4/10/2024, learned family judge Cuttack has allowed the petition and dissolved the marriage between petitioner and opposite party number 2 on the ground of settlement. The petitioner is seeking quashing of issue notice to opposite party number 2. So in the next time, in the meantime, proceedings before so and so state. Yes.
29.
Though the petitioner has challenged the affair, my sole motto is, my lord, one, to get a first half and second half order, because this petitioner is the owner of a loader. The person who is the owner of truck, he was granted bail by this Hon'Ble court, whereas I was refused, my lord.
And petitioner is seeking quashing of the entire criminal prosecution arising out of Bami Berry PS case number 82 of 2023 pending before the court of JMFC Burville for alleged offences punishable under section
379, 120.
379, 120B
Read it, section.
IPC read with section
21
21 of Mines and Mineral Development and Regulation Act 1957. At the outset, Land Counsel for the petitioner submits that he would not press this petition, rather reserve his right to agitate the issue before the court below at appropriate stage. However, he submits that submits on instruction that his client would be appearing before the surrendering before the court below on or before 10th of January, and resort to the remedy in under law. He submits that he would move application for grant of bail, which may be disposed of by the court below on the same day. Accordingly, the petition is disposed of with the liberty as spread. If the application for bail is moved, the same shall be considered.
One line may be added. Release of co-accused ABLFL 7179 of 23 shall be taken into consideration.
He is at liberty to raise all the points before the court below, including the ground of parity. Yes. Disputed. Yes.
30.
30 or my lord's kind permission, lordship was pleased to direct to the parties to obtain instruction from the respective clients as to this settlement, because the matrimonial dispute. I am for the wife. Last occasion, my lord was pleased to direct.
Who is appearing?
It's my duty to
Pass over.
30 and 31 both.
31 also.
No, 31. There are two matters also. 30 is two matters.
31.
The 31 is the release of the vehicle, my lord. And the one vehicle released by the depot. Another truck.
Your Lordship, my respect submission, Lordship, this order is passed by the Lordship Assistant Conservator of Forest, Your Lordship, that is appellable, Your Lordship.
Appellable, why you don't do
Your Lordship, they appeal to the light to the Honorable District Judge, Your Lordship.
My lord, this is the one vehicle released by the justice.
Right, but you have to file appeal.
Yes.
For the
And within 30 days.
the present petition.
And within 30 days.
Seeking passing of the order dated.
Or 28/6/2023, Your Lordship.
28/6/2023.
But the facts remain that judgment was passed in 28/6, but 30 days is limited period of limitation.
Passed by the authorized officer come ACF Cuttack, bracket T division Cuttack, in the confiscation proceeding number 34 of 2021. Learned counsel for the, yes, Mr. Mahathir, learned counsel for the state submits that against the impugn order, statute provides an appeal, huh?
Yes, Your Lordship.
Appeal under section?
Yes, Your Lordship. May. 56(2)(e, Your Lordship. 56(2)(e).
56(2)(e) of
Orissa
Forest Act.
Act 1972, Your Lordship.
72.
Learned counsel for the petitioner seeks to withdraw this petition to file appropriate appeal before the competent court of competent jurisdiction. With this liberty, the petition is disposed of. Yes. Yes, liberty I have given.
Liberty, yes.
So that limitation period is covered up. Yes.
Can 31 be taken up? Other side is-
31. What happened? 31. only.
It passed over again.
30. 30 somebody said. Okay, 30 over. Finish it. Yes. You are supposed to get some instruction or something. Yes, Mr. Mishra. What is?
Sir, the two petitioners here, one is a married cousin, sister-in-law. The other is a uncle-in-law who resides at Medinipur in West Bengal. The incident is alleged to have taken place in Tamil Nadu. And the entire family has been entangled in this case.
Last
Last time I said that is there any scope of settlement?
It's my duty to.
The husband and wife.
No.
How are we concerned with the settlement? In what? How can we initiate a settlement?
Who are you?
I am the married cousin sister-in-law. The other one is the uncle-in-law who resides at Medinipur.
Okay.
Blood with
Babulal Agarwal.
yes, great respect to my senior.
And you are for Trishna.
I am for the Trishna. Last occasion, my lord is pleased to, because all family, husband is not before lordship. Now the other person had technically filed petition for quashing anyway. My lord was pleased to direct whether the matrimonial discord can be resolved by way of mediation. My instruction to my duty, just I am not kindly look into my client has sent me a mail. You all have joined together. They all are in one mess. Let them maybe status is father-in-law, mother-in-law's different status.
But the husband will give the. What will he do?
If my lord, if they are not
And what he
agreeing,
says that subject to returning Stridhan
my lord.
and give him maintenance, the husband has to keep
So far, if your lordship was pleased to direct.
What I'll do is I'll stay the proceeding. I'll send it to mediation and they'll participate.
Yes.
Through
If they come
participate in the VC, I'll because matrimonial dispute.
Yes. Now 5-7 cases are there.
So I am sending it to High Court Mediation Center. I'll stay the proceeding and he will participate through VC because they are nothing to do with your husband wife. You are fighting around the cousin sister somewhere.
I will demonstrate how the petitioners are directly involved. Even this case may not be quashed because it has gone to Supreme Court for bail because bail was cancelled for Surya Agrawal. He also filed a petition.
You might have advised your client to file the
No.
After the FIR. So therefore that's the problem.
Specific allegations are there. It is a
basic allegations are cooked up in this kind of thing and by the lawyer.
Well, that is maybe not in this case. Maybe some other cases. Why a girl will
matrimonial dispute? What the cousin sister, cousin brother, and everybody you wrote.
Tuticorin, the accused persons are staying. The girl from Sambalpur, he had given marriage to the family at Tuticorin. And all these petitioners, Millard, if you will see the FIR and the charge sheet, well made out 307, 326.
Persons to the order dated 7/12/2024. Mr. Lalit Mishra has submitted that he has received a mail from his client regarding the issue of settlement. He hands up for the copy of the mail. Reads as and mail important. Reading up to the as per the instruction of therefore as per the instruction of Mr. Mishra, there is a scope of settlement in the matter. petitioner in this case is the cousin.
Sister-in-law. One is the
Cousin sister-in-law of the opposite party.
And number two is the uncle-in-law of the opposite party.
And petitioner number 2 is the uncle.
No, the
With petitioner in 4600 is the father uncle-in-law of the
Who resides at
opposite party.
No, who there joint mess. My submission will be recorded. Joint mess.
It's all right. I'm not entering.
Same roof. I can demonstrate.
Since the opposite party number 2 has consented for the mediation, I feel it appropriate to High Court Mediation Center. High Court Mediation Center coordinator of mediation is director so and so, and the petitioners are at liberty to appear before the mediation cell through the virtual mode. In the meantime, proceeding before so and so is got for state. Do it. If it doesn't happen, we'll see.
Yes, we'll see. Yes.
State.
Obviously.
32. Cognizance is under challenge by lot. Pursuant to cognizance, NBW has been issued. All the co-accused person in the meantime granted bail. Your lordship say first or second or parity, my lord. Injury is simple in nature. I have annexed.
Petitioner is seeking quashing of the order dated 14/7/2022 passed
9/6/2022.
No, 14 you have written in the prayer. Just see
14/7/2022 the lordship that
prayer.
there are two.
There is a mistake, my lord. Cognizance is 9/6/2022.
But you have written 14. What to do? Where is the cognizance?
Base 52 is very clear. 14/7/2022 received CS number 341 lordship
9 14 only. Just see 52 page 50.
Page 52
Correctly you have written.
14/7. Yes.
Why are you creating? You are sure about you. You are petitioner is requesting of the order dated 14/7/2022 passed by JMFC COG in ASCA in GR case number 302 of 2022, whereby cognizance of offences punishable under section
341, 323, 324,
341, 323, 324, 307, 506, and 34 IPC has been taken against the petitioner, and NBW has been issued.
NBW has issued on 9/6/2022.
NBW was issued on the petitioner. And then counsel for the petitioner at the outset submits that he would not press this petition at this stage, rather reserve his right to agitate the issues before the court below at the appropriate stage. He further submits that the co-accused persons have already been enlarged on bail. Therefore, on instruction, he submits that his client would appear surrender before the court below on or before 10th of January and seek remedy available to them under law. The liberty is granted to the petitioner. The petitioner, it is open for the petitioner to move application for grant of bail on all the grounds, including the ground of parity, including ground of rating. Such bail application is moved, same shall be considered on the same day. Yes.
Till that date, NBW shall not.
Till 10th of January, the NBW issued against the petitioner shall be kept in abeyance. Execution of NBW shall be kept in abeyance. Yes.
33.
33, my lord, petitioner challenging the order dated 29/1/24. For this, Lord and Court directed the petitioner to file a civil suit, my lord. In this case, what happened? The petitioner are in suit along with the original person of the Khata 225 Moja Bhede.
Which order you are challenging? 25/9.
30.
Huh?
Sorry.
My learned seniors item is 35 per hour. 35.
Yes. Which item?
33.
33. Yes, 33.
33 gala pa sita 33. Era 34 hoy lordship.
33. 33, 33 non-APS urgent.
minor, sorry.
You don't know your item, everybody is guiding you. Yes, 33, you are sure, 33. Why are you unnecessarily misguiding it? As it is, he is confused. Writing to that, yes. Yes, sir.
My lord, in this case, what happened?
You are challenging order dated 25/9.
My lord.
Yes. What is this order?
Where this Lorraine District Court directed the petitioner to file a suit, my lord. And confirming the judgment of the executive magistrate, that is Lorraine STGM Bhadan, Lorraine Executive Magistrate Bhadan, my lord. The petitioner is possessing the suit land since Hamid and major settlement, my lord. Since long, and the person of the land is originally.
Which part of the order of the sessions judge is hurting you? Just tell me.
The order.
Which part?
Operative person last, my lord, page 22.
22. Okay.
Order. The criminal remission dismissed on contest without cause. The judgment passed in Lorraine Executive Magistrate Tahsildar Bhadan dated 29/1/24 CMC number 18/20 hereby confirmed.
Yes.
My lord, in this judgment, what happened, my lord? The Lorraine Executive Magistrate directed the petitioner to file a suit, my lord. But a suit was filed by the opposite party that was pending since long. And he has not obtained any injunction, my lord. My lord, para 17 of the order, my lord. It was confirmed that para 17, page 17, para 13. Lorraine Magistrate found that there was a apprehension of breach of peace in two cases bearing PS case number 148 of 23 to 99 of 23 were registered relating to suit land. Later, a person was fined. The petitioner Sushant Panda is convert the case 145 to pass order and attachment to repeat paddy crops. There was a chance of decay and which was ready to be harvested. Accordingly, the RI was made a receiver and directed to harvest the crop of the deposit shall proceed on 21.
What do you want? See, the trial court has rightly done it. The Tahsildar.
That is different. I want to say, my lord, the suit is pending. That is different plot, not this plot.
You move application there and tell all these things.
That was mentioned in this case.
I can't go into all these things. Only the trial court says that the title I can't decide. So the appropriate court will decide. And the sale proceed of the crop will be lying there. When the title is decided, it will be disbursed to you. What is wrong in it?
But now the petitioner harvest the crops, my lord. This is the problem.
I can't adjudicate.
This is the problem.
Maybe.
And no order has been passed by the civil court regarding the injunction so far that the opposite party has filed.
Therefore, you have to press your petition there in the civil court. Rightly, the court have done it.
That is a different plot as mentioned in this case.
So then you have to go and tell the sessions court.
My lord, that was mentioned. That was mentioned by the Lorraine District Court.
I can't correct an error committed by them, apparent error committed by them, because you have filed only two.
There is two plot.
There are two impugn order you have filed. How will I arrive at a conclusion that the plots are different?
That was mentioned in the district court.
Then I have to go and visit that area physically. Then only I can do it. That's the job of Tahsildar.
Your lordship may
run it and file a report. You withdraw it and to avail the appropriate remedy. Move application there before Tahsildar saying that you have given a wrong report. You have not. You are not challenging the Tahsildar's report.
Tahsildar is in favor of me, my lord. He is mentioning that a petitioner is in possession.
What to do?
That's why I am not challenging that order.
Avail the remedy, whatever remedy.
The opposite side filed a civil suit and not taking injunction. That was pending since long.
In this proceeding, I can't give you direction there. I'll simply issue notice. You are not.
Status quo, my lord.
No status quo. No, I will not do that. That is the job of injunction suit. Injunction suit will take care of that. Yes. In 145 proceeding, I'll pass a status order. What are you talking? Yes.
34.
Obliged. May I please, Your Lordship. In this case, petitioner is a branch manager of the nationalized bank. When he was proceeded to give notice under section 13(4) of the Surface Act to the house of the borrower. At that time, the brother of the borrower and guarantor filed one FIR that the notice has been fixed on my house, not the house of the mortgagor. And 3 and 4 Hundas are with the branch manager and threatened him to out the house. That is the allegation. Actually, on that basis, charge sheet has been filed and a cognizance has been taken in 3 persons, in the name of 3 persons along with the branch manager. And sanction, without obtaining the sanction, magistrate has taken cognizance in the name of the branch manager. When he was in the duty, performing as a duty under the Surface Act.
Yes, what do you say?
The one Vinayaka Mahapatra has taken loan from the Bank of Maharashtra by creating equitable mortgage is rendered property, Your Lordship. Bearing Khatanam Lordship. During attachment, the bank authority had attached another plot. The inside the plot of present belongs to the present petitioner also. Therefore, the present informant raised voice. At that time, the bank authority, the present petitioner, used strong language to him and abused in filthy language. And there is a tussle between bank manager and
thereafter the FIR is
yes, that is there,
yes.
Your Lordship. That is the 35 with the charge sheet, Your Lordship. And that is the allegation.
You argue that in
It is not possible.
the framing of trial, Your Lordship.
I don't know it is possible or not. You have taken a surface notice.
Yes.
Somebody else has taken
And
loan.
another property.
You went to somebody's house and pasted it. There was a quarrel took
that
place.
is not possible.
You scolded and everything happened.
No, my lord.
I am reading page 35 of
Kindly answer to that is 13(2) notice. And plot number khata number already mentioned and valuation report already made. How is manager go to the another person's house?
Where is the plot number written?
लोन नेले होची खाता नंबर 522 1923 प्लॉट नंबर 1967
17.
17.
Yes.
Plot number 1699.
Plot number.
1699.
Where is that?
Page 17. Equitable mortgage of land and buildings and details are adjourned.
Yes.
On that.
Covered under Khaitan number 522 of 1288. Survey number so and so. And now so his complaint.
Plot number 1699.
1699. Yes. Show me.
How manager?
Show me the complainant's plot.
The complainant right.
Page 35, Your Lordship, then charge sheet is clearly mentioned. Your
Where is
Lordship.
that?
Page 35, Your Lordship.
Yes. Yes.
During course of investigation, it came to light that the elder brother of the complainant, namely Vinayak Maharana, is credited a sum of rupees 40 lakhs from the Bank of Maharashtra.
Show me the plot number, that's all.
Yes,
I don't
thereafter, Lordship. Branch at Barampur with keeping mortgage the land.
It's the plot number 1697.
1699
was the mortgage property. You went to 1697.
Yes.
What to do? That's the charge sheet. No, will not make no, sir. Come to charge sheet. Charge sheet just plot khata number 522 oblique 1923. Plot number 1697. You went there. You are supposed to go to come to your surface notice. Come to your surface notice. You are supposed to go to the plot number 1699.
Yes.
You went to 1697.
Branch manager.
I'm not inclined. I'm not inclined.
And sanction has not obtained, my lord.
That's a different story. Right.
The branch manager
sanction is not.
servant.
Yes. Petitioner is seeking quashing of the order dated. Order dated. Where is the cognizance order? Order dated 21/8/2023, passed by.
My lord, kindly take the another date.
TJM Chhatarpur, Ganjam, in PR case number 404 of 2023 for offences punishable under section 294 of the 323 of the 341 of the 447 of the 504 IPC. IPC. I have perused the charge sheet and related document form part of the charge sheet and the document relied upon by the petitioner. I am not inclined to entertain the petitioner in this case. Therefore, the same is dismissed. However, liberty is granted to the petitioner to approach the court below at appropriate space.
I may be permitted to get the at the
Yes,
time.
I have said that. You file a proper application there. Yes.
35. May please, ma'am.
1 minute. 1 minute. 1 minute. I'll get 33 na. 1 second. Na? I'll just complete the sentence. 33 thila na? 34 thila na? 1 minute. The petitioner, counsel for the petitioner submits that the petitioner has the bank officer, those who have gone to execute the surface notice, and the informant has created obstructions, and as a result of which the quarrel took place, leading to registration of the FIR. It appears the complainant, the case of the complainant is the bank officers have instead of affixing instead of taking possession of the
mortgage
plot number 1699 in Khaitan serial number 522 up to 128886. They have forcibly entered into the premises of the complainant, which is plot number 1697 in Khata number 522 of 522 oblique 1923 1923. Yes. Yes.
35. May please, ma'am.
Yes.
Directly covered by his mother. This is everything is same as PS case and all regarding the court keys. You have already passed the order. Only one change, my lord, should be required here. Paragraph 7. Can you come to paragraph 7? Instead of learned trial court, it should be courts below.
7.
Paragraph 7. Instead of learned trial courts, it should be courts below. As your lordship.
7. Learned counsel for the petitioner submits that the petitioner.
I'm sorry, parent. I'm inclined to allow the petitioner, I give him liberty to the petitioner to appear and surrender before the courts below. Instead of learned courts, trial court, the courts below. Like the lordship has modified. And one line, the bail application is to be considered on the same date. Rest
Yes.
of it is
What do you say? You are also one of the accused. You are also one of the accused.
same.
Same FIR.
Same FIR, same PS
So
case.
the facts remain the present person is an absconder, offense 302.
Everybody was an absconder. All.
He was also, this man was also,
Yes.
Ajay Kumar Jana was
The
also.
original order was, the original order which your lordship had occasion to follow, manner that order was here. We have annexed it in this rate. It was an order by coordinate bench of your lordship, manner, page 102.
102.
102. This was the order which your lordship followed and quoted here in this order. You got the
Okay,
page
okay.
102
Yes, your lordship. Yes, that order is
That I have quoted here in the.
coordinate benches.
appeared in that.
Yes.
So I'll pass the same order.
Yes, lordship.
Same order.
Yes.
It has,
This modification, minor modification.
court below, it has already corrected.
Same day what taken yes.
Same day.
Same courts will have same. Correct.
क्या कर दो? And I think everything is same.
Everything.
Everything same.
Not a change.
Not change you, it change you, couple 8 across the sports video it same day. It's a correction.
Sir.
Correction. Correction that incorporate for the ठीक दिमाग में तो
Great. Urgent copy. Great.
36. May I please? I have filed this application for rejection of my 311 petition, my lord. Yes, yes. Now the matter has been settled between the parties, my lord, for which I filed an
311.
application.
311. Your lordship.
Seটা compromise ହେଇଯାଇଛି, ଏବେ ତ କରୁନାହାନ୍ତି. Hello.
You are you
PW
22.
Yes, ma'am.
The IO, na?
IO and PW 2, 3 and 4. Father, mother and victim.
No, you are asking
2, 3, 4 and 22.
why will you bring 22?
22 further cross examination was there.
Why unnecessary?
Only your lordship 2, 3, 4.
You settle the dispute. If you
Yes.
bring IO, then he'll again
Yes,
say
2,
something.
3, 4 your lordship may allow.
Same day kar do.
Yes.
Otherwise, see, they have settled. What is the age of this boy?
Age of the 24.
Girl?
Girl is now 20, same age.
20. Now 20.
The
The date of occurrence, she was.
PW2 is
40.
the victim.
Victim.
Who?
Victim, my lord.
No. Victim is PW3.
PW
3.
Mother PW2, father PW4.
4.
What is the age of this girl? 17 then.
Yes, my lord. And boy age is 24.
Now, where have you said that you have settled this?
Yes, para page 4, para 5, my lord.
Right.
Towards
petitioner is seeking quashing of the order dated 29/11/2024 passed by the additional sessions circumspeaker judge under POCSO Act, whereby his application under section 311 CRPC seeking recalling of PW 2, 3, 4 and 22 has been rejected. Let counsel for the petitioner submits that the parties have already settled their dispute. They are staying together.
Yes.
What? Huh? Staying together what?
No, now they are settled their dispute to marriage elsewhere, my lord.
Means elsewhere.
Aye.
Where have you written that?
Para 4, page 4, para 5, my lord. In the meantime, the matter is amicably settled by the parties in presence of the local judges. Some more materials will not be.
The petition, the petitioner has contended as address. Page 4, para 5. Para 5. Mr. Bishwal appears for the state and submits that the victim PW3, victim PW3, 17. Now what is the age? What is
And now
2015? Huh? Victim,
14 the date of occurrence.
States that on 17 August 2015, the victim's statement has been recorded in being recorded in PW3 of the trial court. At that point in time, the victim was 17 years. 17 years.
No, at that time, my lord, that is
17 years it is written. I can't go beyond record. It is written. What? 14 years, huh?
14 years. Now the age is 24.
14 years. At present, the victim girl is about 24 years. 24 years. Therefore, 24. And counsel for the petitioner submits that since the PW3, the victim, was a minor at the time of recording of evidence, and POCSO Act is invoked involved in this present case. Under section 35, 33 bracket 5, there was a bar for repeatedly calling the minor victim call for the examination. And the counsel for the petitioner, on the contrary, submits that at present the petitioner is no more a minor girl. She is 24 years. So the bar under section 33(5) doesn't operate. Doesn't operate. And the perusal of the contents of application 311 CRPC moved by the petitioner reveals a genuine ground for recalling of the witnesses. Therefore, the petitioner has also enumerated the proposed questionnaires to be put to the witnesses. In that view of the matter, I am inclined to allow the application. Accordingly, the trial court is directed to summon PW 343, PW
2, 3, 4 and 20.
2, 3 and 4.
2, 3 and 4.
2, 3 and 4 by fixing a particular date. And the petitioner, the defense, and it is very clear that neither the defense nor the prosecution shall unnecessarily seek adjournment and conclude the further cross-examination on the same day. With this observation, the petition will dispose of. Please. Because if you call IO, then whatever evidence you get, he will cover up. Then you will be again in trouble. Better don't call the IO.
37.
May I please, your lordship? Unless the arises out of complaint petition, FR was lodged, my lord. The factual background of Mallas.
Previously the same.
No, lordship, for a moment, my lord.
Yes.
The lordship.
Same company.
No, lordship, kindly, my lord. That I have filed NCLT proceeding against the company, my lords. The present complainant here is the party because the illegal affairs of the company as well as the illegal sold the property, my lords. Without the filing appear in the said case, filing the objection as well as the if illegal, my lords, then without filing any application for deleting in name, lodge an FIR. Though I am NCLT in the party, I'm party in the NCLT proceeding, the FIR has been lodged. That is the lordship, may kindly for the page 24. The opposite party number 2 said Miller complainant, though my name was indicated in the NCLT proceeding, this FIR has been lodged.
What are the allegations?
Allegations, my lord. The agreement was executed between the company as well as the present opposite party number 2 and Father Millers. Then subsequently they have entered into the power of attorney in favor of the company. Then Miller subsequent agreement was executed. So far as the share is concerned, Miller. Only they are allotted in the 5 plots, Miller. Then rest of the plot in the company. Then apart from the 5 plots, I'm the one of the director of the company, Miller. Apart from 5 plots, Miller, they have sold excess plot, Miller. That is the allegation. I have filed a proceeding NCLT and all the.
How NCLT is?
No, lordship, for a moment. That illegal affairs of the company, the company property has been sold somebody else.
You are the director. You have cheated people. By...
No. I'm not cheated. No.
Not of the where are you going NCLT?
Lordship, for a moment.
What is that NCLT?
Lordship, for a moment.
You tell me NCLT.
So against the company affairs of the company, my lord, my share has not been.
Under what position?
Yes, lordship, may kindly see a company petition. They have objection.
Show me petition.
134 petition, Millers. In fact, petition is not there.
Under which provision?
The Millers, lordship, may kindly for a moment. Yes, Miller. 134, page 34. I'm sorry, Miller. The page Miller 120.
1 minute.
120 Millers.
241, 242 application, mismanagement and all.
Yes,
that is neither here nor there.
Then now, Miller, why I'm saying, Miller, the opposite party who are doing the illegal, lordship, for a moment, only for a moment, Miller. This is the page, Miller. Lordship, for a moment, the page 96.
What is happening in that proceeding?
Proceeding, Miller, investigation is on, Miller. Yes, Miller.
In the NCLT proceeding.
NCLT proceeding is going on, Miller. That is also and
yet to be established.
No.
Whether there mismanagement was there or not.
I am established. I am not saying, Lord, NCLT proceeding. Why the FIR allegation has been in lordship similar? The where I am included as the opposite party as a party in the said NCLT proceeding. He has said, though NCLT proceeding I am in party, illegal way the petitioner has included my name in the NCLT proceeding.
I don't think NCLT proceeding has any bearing, and
no, lordship,
unless it is recorded somewhere.
Yes, lordship, for a moment, lordship, for a moment. Why I am illegal, same Lord. 96 for a moment.
96.
Like 6, yes. 96 for a moment.
the subsequent agreement, owner share, the first party, who is the present opposite party number 2. The plot number, Lordship may kindly for the plot 105, 106, 205, 206, 306.
Investigation is going on. You tell all these things.
As your Lordship is similar.
I'll tell that. I'll
Yes,
tell
sir.
that.
Your Lordship, last occasion, similar case has been.
As your Lordship has a- I'm not sure. Lordship.
See, he has some point. Not
Yes,
that
sir.
he doesn't have
So,
point.
then-
But if the
then-
IO has to take.
Yes, all. Yes, so Lordship says the Lord, 97, I great Lordship.
Where is that out?
No, Lordship, Dio, another cases, Lordship is directed to.
Where is that? Give me that.
That is not with me, but your Lordship is directed to IO, all these things, apprise and documents is produced.
I'll same language. I'll use that. And
If your Lordship pass it over, I can give your Lordship. I only, I'll 1, 2 over pass it over.
You just
Yes,
pass it over.
I'll
You give it as same order.
Yes, your Lordship.
Yes.
Yes. 1, 2 pass it over.
Yes.
Great.
38. Yes. 38. Early disposal of the criminal proceedings. Who is he? When have you filed the petition? The petitioner has moved an application under section 125 CRPC on the on 11/20/2007. Which is against the party.
Cases can be remember the 10 cases on the prayer of my wife and inquiry was made before the DG and the SP made an inquiry. Reported that there was no such evidence against the prisoner. Considering that, and also as far as the order with respect of other cases, that is posted to 30 January 2025.
Yes, Mr. Vishwas. Same order.
Same order. And PS case change over.
PS case here is correct.
In 43, 44, 45, 46.
How many cases?
46. 10 cases in Osina COVID observed 10 cases.
Total 10 cases.
Total. Already 2 has gone. Only 7 cases before ours. 7.
40?
The 5 cases have been released. 39, 43, 44, 45, 46, 48, 49.
Okay. Only
here and PS cases change. Everything is.
And tag all the matter together.
Yes. And the other cases are listed directly to be listed on 30 January 2025.
No.
That is
the 30 January.
30 January. 30 January.
And 40.
40 or something can be passed over on behalf of Mr. Dick.
40.
Yes, ma'am.
40.
Yes, ma'am.
Exactly. Maharaj asked for pass over.
No, I was in footnote 6. I went to footnote 6. I just came.
Yes.
Yes, ma'am. Here, I prefer passing the proceeding
Lordship Annexure 1, page 10. Here offenses are 341, 323, 294, 506, 34 IPC. Lordship, see the FR page 11 on Mahendra Kumbhar, that father's daughter, that his daughter, namely Minati Kumbhar, was given immunity for Himanshu Harpal 8 years back. And there was some dissension arose between the petitioner, her daughter and his son-in-law, which leads to that her daughter left the in-laws house and staying in her house. It is alleged that during absence of the informant, the petitioner, who happens to their family member, they have aid and abetted her daughter not to go to her in-laws house. That is what the allegation.
So why should it be quashed?
You see the charge sheet at page 22.
Why should it be quashed?
May please page 22. Yes.
You tell me what are the grounds for quashing?
In fact,
you have filed the FIR copy and charge sheet.
Yes.
But you tell me why and what are the documents?
No, in fact, only allegation that they aid and abetted dispute between husband and wife, the informant's daughter and son-in-law.
Go into all these things. You want me to appreciate 161 statement at this stage?
No, charge sheet there, cognizance was taken, and we are on bail. That's not the.
That's right.
Lordship,
What are the grounds?
Lordship, keep it after vacation. I will.
You will manufacture ground.
No, you will keep it after vacation in the meantime.
Do you have any ground? I will give liberty
Yes.
to move application. I will tell
No, you will keep it after vacation. I will.
I'll tell you.
I will call for
See, there is no point keeping it. I will give you liberty, move specific application. You say that this offense is made out or not, that will be tested. And after vacation also the same thing. Why? I am giving you full liberty. You move an application, ask for discharge insofar as many offenses are concerned. They cognizance is also not taken.
No cognizance.
So therefore, how can I'll just give you
No, cognizance order is not there with me, but cognizance already taken.
I'll give you liberty. Petitioner is seeking passing of the charge sheet number. Charge sheet number क्या है? नहीं, charge sheet number 253, dated 16/9/2018, arising out of Bolangir PS, Titlagarh PS number 253 of 2018 for alleged commission of offences punishable under section 341, 229, 294, or 323, 506, and 34. 506 and 34. On various grounds. I am not inclined to entertain this petition at this stage. However, the petitioner is granted liberty to move specific application before the trial court for discharge. For discharge, if such application is moved, the same can be considered on its merit. On its merit. And pass it is expected that the trial court shall pass a speaking order. This.
Thank you.
I have given the trial court has to pass a speaking order on your application. Yes. Move application. Yes. I'll just come. Yes, sir.
126 that mentioned. Let it be first week house. Because
we will give it.
she was there, people will care. So inhuman to us. All
I just come.
7 Millers. Let's say the paragraph 2 is concerned, Lordship, paragraph 2 is concerned, Miller, Lordships, that Lordship may indicate it, Miller, the annexure 5, that is the additional agreement was executed.
Item
37, Millers.
37 item.
Yes. Actually, may I submit one thing?
Same FIR?
No, Lord, same not FIR. That is the subsequent FIR. Lordship is similar case pass first type of order.
Petitioner is seeking 37. Petitioner is seeking quashing of the FIR, which is Balyanta. PS case number 308 of 2023. Registered against him for alleged commission of offences given under section 397, 403, 406, 420, 506, 120 IPC. IPC pending in the court of
JMFC.
Oh
yes, Bhubaneswar. Lordship may indicated annexure 5, the additional agreement was executed for the.
I am asking something, you answer first. Which court now?
JMFC O Bhubaneswar, Millers. Yes. JMFC O Bhubaneswar. I'm sorry, Miller.
The matter is still in the investigation stage. Therefore, I'm not inclined to enter into the merits of the case at this stage. Right? Our liberty granted to the petitioner to apply all the facts and grounds mentioned in the original petition. And the IO is expected to deal with the same in accordance with law. At the time of filing for the report of the final form on section 173 CRPC. Petitioner is then consider the petitioner has relied upon
annexure
documents annexed with the petition
annexure
228.
Yes.
228. And he may produce these documents before the IO who shall take into consideration in accordance with law. Yes, this for that. Yes, compromise matter which one? 100?
100.
Yes. Aadhaar card. Yes. What are the offences?
Under section 376(1), 323, 294, 506, 34.
Sorry. 276, 323, 4. Charge sheet has been filed?
Well, no, charge sheet have not been filed.
Charge sheet has not been filed. What are the settlement? Where is the affidavit?
Well,
You are the informant, huh?
Yes, ma'am.
Rumadar. Who is the who is the informant? Father. Father of the victim girl.
Giving the brief, my lord. It is a unfortunate situation have been made. I'm concerned that what happened. These petitioners are the father of a kid. After birth her child, he's come to the Baleswar hospital. She admitted her daughter. Another boy, he also come for another treatment. What happened? Out of anxiety, he take back this boy and leave that girl. Then he cried, again he came back. That time police came. He surrendered, he is arrested. In the meanwhile, he has got to the custody.
What have you moved this application?
Now I moved the application, the file application before the land. JMC, SDJM, it was transferred to JMC Baleswar. He rejected ultimately the ground, last paragraph.
What application you moved?
With the custody of the child. Because now what happened, this child was, because he was arrested and gone to the police custody, it's a very highlighted case in the period time. Nobody is claiming his parent about child. So that definitely the state administration hand over to the Baleswar. Now see the daughter is there in Baleswar. There CW says that this the SDGM has rejected your case for giving custody. How can you give?
Who is the natural
These petitioners are natural parents. This evidence document.
What is the age of the child?
1 year, 1 month, 1 month.
Issue notice.
1 month.
One month child, it has to go to
1 month.
parents.
Okay, now in 5-6 months is there.
Okay.
Now is 5.
I'll issue notice.
As per the order of the JMFC, now is CEG 8 months.
8 months. It's all right, but less than 1 month, less than 1 year.
What time?
Natural parent has to take it. Yes, yes. Issue notice and lease it on third. Get instruction. I'll have to allow it.
My lord,
Less than 1 year boy, the mother, the natural mother and the father are asking.
every day they are going, they are giving you foods, but
How can you keep somewhere else? You are depriving the right of the child. Third.
my lord, third I will be absent at 5th or 4th.
You may not come, I'll allow.
Yes. Oblige, my lord.
You have to see the child's.
Yes.
You send someone, I'll.
Yes.
He'll seek instruction. You seek instruction and tell me. If any legal impediment, there is no legal impediment. And factually, if there is a problem, if you are disputing that they are not natural parents, then it's a different story.
Yes.
If they are natural parents, then custody has to go.
So that part nobody is disputing. But thing is this.
Let it very.
Yes.
Third.
Let them, yes.
Third.
42.
Oblige.
500 महिला 500 आगे
47.
May I please, your lordship? Lord, here the petitioner seeks to challenge the order dated, my lord, 4/11/2024, my lord, at page 80. 80, my lord, passed by the London Appellate Court, by the London Sessions Judge Devgowda, my lord. That one originally, my lord, that SDGM passed an order, my lord, maintenance in the DV case, maintenance of rupees 10,000 and my lord, compensation of rupees 30,000, along with other orders, my lord. The husband preferred appeal. In the appeal, he filed a stay application, saying that he has been paying, my lord, rupees 3,000 to the daughter, and it was also admitted during cross-examination by the wife. I'll be showing, my lord, from the records that he has been paying 3,000 rupees per month, and both are teacher, my lord. The husband and wife both are teacher, and
the question of maintenance of the child.
Yes, and despite that, my lord, lordship, kindly have a paragraph 6, as page 82.
82.
My
It's okay. Admittedly.
My lord, admitted. The respondent number 1 is the wife of appellant number. Respondent number 2 was born out of their wedlock. The respondent number 2 is studying at Holy Child KG School at Ralkala, and she is studying with her mother. The age of respondent 2 is 11 years. My lord, I will just present for a moment, my lord. Lordship, kindly have a glance to the another deposition of, my lord, the DW1, my lord, as page 24.
What do you want?
My lord, I want to stay.
You don't want to pay 3,000 to your daughter.
No. I have been paying.
Government sort of the matter is you don't want to pay 3,000 rupees to your
10,000, my lord. 10,000 rupees has been awarded.
3,000 is awarded.
I know, my lord. 10,000. 10,000 awarded. I have been paying 3,000 to my daughter.
You pay.
My lord, I have been paying, but unless
working as a teacher.
My lord.
So why are you not paying to your own daughter?
My lord, I'll until unless
the daughter is studying in a very good school.
No, my lord, she is studying in a government school. That's why I wanted to.
Where is that government school?
My lord, that's what I want to point out to a lot.
Show me.
Page 24.
24.
My lord.
Okay.
Page 24, paragraph 15.
24.
My lord.
Yes.
Petitioner is a government teacher and drawing such and such salary. Petitioner number 2 is studying government primary school, Turan, and staying with her auntie. Next one, the midday school, school dress, etc., etc.
Whose affidavit is this?
My lord, this is the deposition of my lord husband.
Husband is saying.
In fact, my lord.
You may say whatever.
No, my lord. It also supported by the wife. I have an additional affidavit.
Show me the finding which you have shown me now.
I will address your lordship to that deposition of wife, my lord. Inadvertently, it has not been filed. I'm filing.
What do you want now? You don't want to pay or what?
No. I have been paying, my lord, until unless your lord, that proceeding is, my lord, that order is stayed. On that appeal will be infructuous, my lord, because 30,000 rupees compensation is there. I have been paying 3,000. I may suggest, my lord, I will be paying 5,000 rupees per month.
At the other court will decide. I am not here.
My lord, but the court outrightly rejected on the base, my lord, and the non-application of mine. and says that she has been studying in a my lord private school at Raulkala, but that's not a fact. That has been my lord admitted by the wife my lord in the cross examination. Lordship, kindly have a glance. The page my lord 16. That additional affidavit.
Wife.
Yes, my lord.
Bijuli Pradhan.
Yes.
Yes.
Paragraph 27, page 16. I don't have any facility, so I kept my child in Raulkala in my parents' house in for education. Para 27, page 16.
Yes.
My child is studying in CORAM Primary School, Devgarh, which is a government school, and staying in my sister's house, Meenakshi Pradhan, under her care and custody. And with regard to payment of 3,000 that admitted, my lord, paragraph 36.
Maybe you are paying.
Paragraph 36. That I have been paying 3,000. It can be enhanced to 5,000, my lord. I will be paying.
That I can't decide.
And that compensation part also until unless.
Issue notice, let us see.
Yes. And there is every chance for settlement because I have
issue notice. I am not saying anything. If you are paying 10,000 rupees for some time, we'll see.
My lord, I'll be filing that one adjournment application at least till see.
It's a matter of 10,000 rupees. Keep on paying. I'll decide it. Bring her.
And with regard to that 30,000, my lord, because
what is happening to your marriage?
My lord,
what is happening to your marriage?
That is still subsisting, my lord. And in fact, I have filed an application under Section 9 of Hindu Marriage Act to get back my wife.
There is a chance of
There is a chance
I'll
of
issue notice here.
I'll be paying 10,000. But may I suggest, my lord, that 30,000 compensation, Lordship at least may stay that compensation part because on the ground of cruelty.
You want stay of what? Which one?
My lord, that order passed by the SDGM, my lord.
The impugn order dated issue notice to impugn order dated 4/11/2024.
Yes, ma'am.
Passed by the additional sessions judge Devgarh in criminal appeal number 1 of 2024. 1 or 24?
Yes, ma'am.
Is stayed till further till next date of hearing, subject to petitioner continuously paying the awarded maintenance amount of 10,000 rupees per month.
Mild.
50.
May it please your lordship, ma'am. Here, my lord, the victim eloped with the petitioner. Thereafter, she was rescued from the house of the petitioners one day after. 164 statement was recorded, my lord. Your lordship may see page 15.
15?
Yes, my lord.
Yeah.
15. Annexure 3, page 15. She has totally denied. She was 17 years by that time. She has totally denied of any offense.
He has already deposed against you. 311 I can consider.
Grateful,
You
as please.
let's see 2014 FIR. Much has changed now.
Yes, 311, that is page 20 is my application, 22 is the impugned order.
Where is the application? 20?
Page 20, it starts, my lord, annexure 5.
He had deposed when?
She had deposed in 2015. That is September 2000.
That time she was 17.
More than 17.
Where is the application? Show me application.
Application is annexure 5, page 20.
Questions वगैरह.
Yes.
Right. Petitioner is aggrieved in this petition is seeking following relief. The trial of the case is at an advanced stage. Therefore, I am not inclined to entertain the first prayer made by the petitioner in the proceeding regarding the quashing of the entire criminal proceeding. However, the order dated, where is that order rejecting your application?
That is page 22, my lord.
However, the order dated 9/10/2024, whereby the application made by the petitioner under section 311 CRPC for seeking recall of PW1, which has been rejected, deserves merit to be considered. Because The FIR was registered on 29/12/2024. The victim girl, a statement of the victim girl during investigation was recorded under section 164 CRPC on 2/1/2014.
14.
In the statement, in the said statement, petitioner, the victim girl has absolutely made no allegation against the petitioner.
Yes.
However, when she has deposed before the court on 8/9/2015, she has taken a different stand, different stand. In that view of the matter, the petitioner moved an application under section 311 CRPC for seeking recall of the said witness. The victim is at present, what is the age at present?
She will be about 26 years now.
At present is 26 years, 26-year-old. Therefore, the bar contained under section 33(5) for under POCSO Act regarding repeated calling of the minor doesn't operate against her. I have perused the application made by the petitioner under section 311 CRPC. With CRPC questionnaires you have
Yes,
said?
questionnaire is there in the application itself.
And evaluated the and also gone through the proposed questionnaires framed by the petitioners to be put to the witness, I am satisfied that the application deserves merit. Accordingly, the same is allowed. The trial court is directed to recall the PW1 by fixing a particular date, and the petitioner shall conclude the further cross-examination of the PW1 on the same day without seeking unnecessary addition. Accordingly, the petition is allowed and direction. Yes.
Great.
164 statement was recorded in the year 2015. It is wrongly has been reflected here.
Right.
Actually, the date of incident is 29th.
1 minute. 48, na? Item 48. Yes. But 164 statement, I'll show you.
Wrongly January 2014, it will be 15.
No, item, which item?
Same 50, item 15. Your lordship has
50,
detected 2014. It should be 2015.
No, but it is 14.
No, my lord, in the end of the 164 statement, that's the date which has been put by the learned magistrate. It is 2/1/2015. Because by 14, there was no offense. I mean,
but it is in the
wrongly, yes, in the deposition.
Though it should be
2015. 2/1/2015.
2nd January 2015.
Right, my lord.
15. Yes.
Urgent copy.
51.
Please, your lordship.
Yes.
My lordship, this is the petition has been filed by the petitioner.
But this was dealt by the other bench. You would go to that bench.
My lordship, it has been roster system. It has been roster.
But it was dealt by the other court. It has to go. Release the matter.
Modification of the bail order.
Bail has granted.
Challenging the unbeatable also.
Whatever, you go there. Release the matter before so of taking permission.
Indicating the name of Mr. Vivekananda Bhuya appearing for OPID case. Vivekananda Bhuya.
Vivekananda Bhuya appearing for the OPID points out that the bail was granted by the coordinate bench. So therefore, ideally, this matter needs to be placed before the same bench. Least before state bench, subject to permission of the chief justice. Yes.
52, my lord, I prayed for adjournment only. Because medical report is required.
Okay.
Only adjournment.
Yes.
Hon'Ble.
Yes.
53.
May I please, your lordship. This petitioner is challenging the order dated 5/12/24, your lordship.
Order dated?
5/12/24, your lordship. That is at annexure 4, page 15.
Yes.
My application under 313 was rejected and the matter was posted for judgment without affording an opportunity of hearing, your lordship. Your lordship may kindly see the date chart I have given. The matter was posted for defense evidence on 11/9/24, on which date the PO was on CL, your lordship. And thereafter the matter was posted to 8/10/24. On that date, the PO was on training. And again, the matter was on posted to 22/10/24, your lordship. And
the petitioner failed to take any steps.
Yes, your lordship.
That's
Only because on a single day I failed to take any step, the matter was posted for judgment and my evidence was closed on that day, your lordship. This is a matter arising out of 138 NI Act, your lordship. And it has been posted to 27/12 for judgment.
So what to do? You have, you have taken so many adjournment here. 2023, the complaint case.
No adjournment I have taken, your lordship. Only a single date I have not taken any step.
What is the check amount?
9 lakhs, your lordship.
9 lakhs. 143 you complied.
143, your lordship. This is
deposit. 143, comply 143, I'll give indulgence.
Your lordship, this is a trial has not.
I know. If you are convicted, then 148.
Yes, your lordship.
Before, during trial, 143.
Yes.
Comply. That will be kept in, it will not be disbursed to the complainant. Right. Because if I issue notice, then again it will take time. When is the date fixed there?
27/12, your lordship.
February.
December 27/12/24.
Where is that? Show me.
That is annexure 4, page 17, your lordship. Put up on 27/12/24 for judgment, and learned advocates for both the sides may submit their argument meanwhile.
Madam, petitioner is agreed by the order dated 5/12/2024, whereby his application for leading defense evidence has been rejected and the matter has been placed for final disposal on 27/12/2024. The petitioner has filed a date chart which indicates that the matter was posted on 11/9/2024. The matter was posted for defense evidence, but on that day the PO was on leave. The matter was adjourned to 8/10/2024. The PO of the presiding officer, PO, was absent as he had gone for training. Again, the matter was taken up on 22/10/2024. On that day, it appears that petitioner has failed to take necessary steps to produce the defense evidence. Hence, the defense evidence was closed by the. On that day, order was passed. The Land Trial Court closed the defense evidence.
That is under annex.
Subsequently, the petitioner petitioner moved an application for leading defense evidence. Defense evidence filed on. So
4/11.
Petitioner moved an application dated 4/11/2020, which has been turned down by the impugn order dated 5/12/2024. On the relying upon the same aforementioned timeline, the aforementioned proceeding sequence of proceedings, then counsel for the petitioner says that it is the petitioner has only defaulted for one day, by not able to produce its evidence. However, the trial court close the defense evidence and place for final disposal. In that scenario, he submits that he may be afforded one opportunity.
Yes.
One opportunity to lead the defense evidence. The prayer made by the petitioner deserves merit. Therefore, deserves merit. Ideally, the notice should have been issued to the complainant, opposite party number 2 in the instant case. But however, since the matter is fit for final disposal on 27/12/2024, I am of the considered view that the trial court should afford one opportunity to the petitioner to lead the defense evidence by fixing a particular date. The petitioner, being the accused, shall conclude the defense evidence on the same day, without seeking any additional. Next paragraph. Accordingly, it is directed that the trial court, trial court also shall fix a date. For recording of evidence, defense evidence, and afford an opportunity to the afford a singular opportunity to the petitioner, subject to the petitioner depositing 10% of the check amount before the court window. The check amount, 10% of check amount to be deposited shall not be disbursed to the complainant at this stage. The same shall only be shall only at this stage. However, the trial court it is open to the trial court to take necessary to make necessary direction at the final stage of regarding the disbursement of the 10% to be deposited by the petitioner. 10% deposit.
10% lordship may be invested in an interest bearing account.
It will be over within 10-15 days. What interest bearing? Yes.
Obliged. Urgent certificate.
54.
Item 54 में kindly password mail. Mr. Bose will appear.
Yes.
55.
Yes.
May I please, Lords?
Yes.
This matter, Lordships, I have filed only for the ends of justice. It requires my Lord's consideration. Lordship, kindly come to page 50. Allegation against my client.
50. Yes.
May I read, Lordship?
Yes.
ମୁଁ ଅକ୍ଷୟ କୁମାର ଦାସ ଆଜି ତାରିଖରେ ଦେବା ବୟାନ କି ଯେ ତାରିଖରେ ସନ୍ଧ୍ୟା 9ଟା ସମୟରେ ମୁଁ ମୋର ଘର ସୀମାପୁର ଯାଉଥିଲି। ଠିକ୍ ସମ୍ ହସ୍ପିଟାଲ ଠାରୁ କିଛି ଦୂରରେ ଆମ ଗ୍ରାମ ପାଖରେ ଦେଖିଲି ଗୋଟେ କାର୍ ଖୁବ୍ ଜୋରରେ ଯାଉଛି। ରାସ୍ତା ଉପରକୁ ହଠାତ୍ ଗୋଟେ ଗାଈ ଆସିଯିବାରୁ ଡ୍ରାଇଭର ଗାଡ଼ିକୁ କଣ୍ଟ୍ରୋଲ ନ କରି ରାସ୍ତା ରୋଡ ଡିଭାଇଡରରେ ପିଟି ଦେଲା। ଉକ୍ତ କାର୍ଟି ରାସ୍ତା ଉପରେ 2-3 ଗଡ଼ା ହୋଇ ପଡ଼ିଲା। ଆକ୍ସିଡେଣ୍ଟ ହେବାର ଦେଖି ସେଠାରେ ଲୋକ ଜମା ହେଇଗଲେ। ମୁଁ ମଧ୍ୟ ସେଇ ଗାଡ଼ି ପାଖକୁ ଗଲି। ପାଖକୁ ଯାଇ ଦେଖେ ତ ଆକ୍ସିଡେଣ୍ଟ ହେଇଥିବା ଗାଡ଼ିଟି ଗୋଟେ ହୋଣ୍ଡା ସିଟି କାର୍ ଅଛି। ସେଇ ଗାଡ଼ି ଭିତରେ 4 ଜଣ ଲୋକ ଥିଲେ। ଡ୍ରାଇଭର ପାଖରେ ଆଗ ସିଟରେ ଜଣେ, ପଛ ସିଟରେ 2 ଜଣ ଥିଲେ। ଲୋକମାନେ ସେମାନଙ୍କୁ ଗାଡ଼ିରୁ ବାହାର କଲେ। ଗାଡ଼ିର ଡ୍ରାଇଭର ସିଟ୍ ଓ ଆଗ ସିଟରେ ବସିଥିବା ଲୋକ 2 ଜଣ ବହୁତ ଖଣ୍ଡିଆ ଖାବରା ହେଲେ, କିନ୍ତୁ ପଛ ସିଟରେ ବସିଥିବା ଲୋକ କିଛି ଗାଡ଼ିରେ କିଛି ହେଲା ନାହିଁ। ଠିକ୍ ସେଇ ସମୟ PCS ଆସି ତାଙ୍କୁ ନେଇଗଲେ। ଲର୍ଡସିପ୍, my client was the driver.
Driver of that Honda City.
Honda City, the owner of the vehicle, and who died, he was his friend. Both were coming, and sudden appearance of this vehicle met with the accident. Client also treated in the hospital. He succumbed to death. Now, pursuant to which, Lordships, a MACT case was filed that the deceased has received the compensation that is at page 11, Lordships.
Yes.
MACT. The last portion, order portion is 38, page 38.
Yes.
Oh, he has received 38 lakhs, some odd amount. That's it.
The person who has died, the victim, was in your car.
My God, he was sitting in the left side. Though sudden cow appeared, He died. And the
He
person
also received injury. It's a matter of action.
compensation.
He seeks for
Because no purpose will serve thereafter.
I'll issue notice.
Yes, sir.
I issue notice and meanwhile, yes.
Because due
And
to
see,
pendants.
the idea of these cases are only for compensation. He got the compensation. The victim's family has got the compensation. And he himself is also a victim. In true sense.
Let's.
Because he was driving in
Friend of the.
it's a harsh case. Stay the proceeding. Yes.
କାହିଁକିନା ମୁଁ ସେ ପାସପୋର୍ଟ ବି ପାଉନି ପେଣ୍ଡିଂ ପାଇଁ ଏଇ ଯୋଉ କେସ୍ ପେଣ୍ଡିଂ ପାଇଁ ପାସପୋର୍ଟ
I issue notice, stay the proceeding. Now you move application. Now you move that. Yes.
Let's.
Since I have stayed the proceeding, you can move a fresh application. Land counsel for the Mr. Naik, land counsel for the petition submit that he would move an application for
issuance of passport
for release of the passport. If such application, irrespective of the stay being, irrespective of the trial being stayed by this court, the application may be considered on its merits.
issuance of fresh passport.
Whatever I said that you move application. Otherwise, if I stay, you move application, he will not dispose of your application. So therefore, I clarified that irrespective of the stay, the application will be decided. You move up.
Humble.
May I please ask?
Which one?
56 man.
He oral prayer.
56 my lord. And in this case, my lord, as page 15, my lord, I have 3 prayers, my lord, but I am not pressing 2 prayers, my lord, and only when pressing direction to the court of honor decision sessions are concerned to take decision on the merit on the petitioner dated 16/12/2015 in the CMA number 10 of 13, my lord. What happened in this case, my lord, the opposite party to having a company, my lord, Deepak Steels and Power Limited, my lord. That case you lordship already vigilance case, my lord. The lordship will have that case on earlier occasion, my lord. But in fact, my lord,
who are you?
We are the employee of that my lord, the company, my lord. We have already solved copy on the senior counsel, Mr. Panigrahi, my lord. Last occasion, my lord. But in fact, what happened in this case, my lord, they have the company, my lord, filed a petition before the court below. On my lord, that is the annexure 5, page 86.
What are you asking then?
Pending the only, my lord, I pray, my lord, the application dated, my lord, the annexure 5, 16/12/2015 may be disposed of, my lord. Not married, my lord, I am not saying, my lord, disposed, so that the petitions, my lord, 4 petitions, my lord, they are employee of that company, my lord. They will get all the benefits and all the, that is, it will run, my lord, again, my lord. The company will run again, my lord. They will be employed in the company, my lord. My lord, limited prayer, my lord. No, copy already solved.
What they are saying is an application which is pending in 2015, let it be disposed of. What is let it be disposed of?
Employee, I mean, so we are the employee, my lord. We are the employee, my lord, but that company, my lord, only, my lord.
Prayer is innocuous.
Innocuous prayer, that is my lord. I am a disposal correct that much, my lord.
In that company,
I am
confiscation.
They will pass the order.
Confiscation.
The lawsuit jurisdiction will not come.
No, my lord. Pending. My lord, we are.
I'll just observe and dispose it.
Exactly, my lord.
I will not say anything, but innocuous prayer, so it is expected that the trial court should do well to.
Exactly, my lord.
Petitioner is seeking Mr. Petitioner in this petition, petitioners are seeking following relief. At the outset, Mr. Ragada submits that insofar as the first 2 prayers in the petition is concerned, he is not pressing. He is following prayer. Mr. Maharana appears for the vigilance and submits that the petition itself is not maintaining. And he strongly opposes the prayer made by the petitioner in the present proceeding, invoking the jurisdiction of this court under 482 CRPC. CRPC. In response to the said objection, Mr. Ragada submits that he would not press insofar as the first 2 prayer is concerned. However, insofar as the 3rd prayer is concerned, he seeks indulgence of this court only on the ground that the application sought to be disposed of by the trial court is pending since 16/12/2015. 16/12/2015. Since the prayer made by the petitioners seems to be innocent without prejudice to any stakeholder. I'm inclined to entertain the same in this proceeding to meet ends of justice, and accordingly the trial court is directed to do well to see that the application, what is that application? CMA number 10 of 2020, 2030.
No. CMA application, there is application determined Annex 5.
Annex 5, what is that? Annex 5.
The application to opposite party continue to commercial
see the application moved by the, who has moved that application?
The company, opposite party 2 ballot.
Then it will be problem. Current company, that the company is facing trial in criminal case, that is a confiscation. Now he wants to enter that premises to carry out the operation.
Merit reject how does it make it? That also I'll write you. Your question in the locution. Is disposed of in accordance with law. In accordance with law. Therefore, Mr. Mahana is also questioning the locus and of the petitioner to move such application. I am not entering into the merits of the case in any manner whatsoever. However, this out, however, this. Oblige.
Here the appellant before my lord has been convicted for the offences under section 13(2) read with 13(1)(c) of PC Act along with section 409 of IPC, my lord. And he is in custody since the date of the judgment, my lord, that is 6/12/2024, my lord.
4 years conviction, regular appeal.
My lord.
Regular appeal.
My lord.
Yes.
And the appellant is in custody, my lord.
Bail, grant bail and all orders. Yes.
And stay of fine.
Mr. Sanjay.
Oblige,
Yes.
my lord. He copy be granted.
Yes, next.
Item 58 and 59, my lords. Both the matter, the fresh matter, let notice go, my lords.
Another matter is.
The same petition filed two revision, my lords. Arising out of the same PS case, my lord, and but two different years.
I issue notice that issue notice.
Another connected matter has not come.
Give the number, leave that matter also. Okay. 58, 59, notice. Yes.
60.
And if a lordship may submit, if my learned friend relies on any similar judgment, may copy may be supplied to me.
I have annex of 7. I have annexed the judgment.
Issue notice, huh? So second week of January? No, second. Yeah.
Let's say if a lordship permits, if a lordship want to be 16, 128 is item of lordship brief, lords. Maybe noted, my lords, 128, my lord. I have to take instruction that matter.
No, is it related to 60?
No, my lords. I'm lords, 128 of lordship, today's cost list, my lords. They have to take instruction.
128 note kar dito, urgent ko.
Item 60.
60, okay.
60, my lord, it will be taken up in along with 128.
No, it's a different thing. He's just mentioned.
My lord?
Nothing to do with this
matter.
matter.
Nothing to do with it.
Yes. Yes, sir.
My lord, may I please your lords?
Yes.
My lord, I have challenged that order dated 19/11/2024. It is the application filed by the present petitioner to discharge him from the offence under section 3 of the PMLA Act.
Okay.
19/11/2024, lordships, your lordship will find it as page 326.
326.
My lord.
Yes. Yes.
Under Annexure 7. 19/11/2024. My lord, your lordship may kindly see the fact of the case. I am one company and the managing director of a company. My lord, I have a valid license to procure opium. Accordingly, I have procured, there is a procedure, my lord, for procurement and utilization. I have a valid license. Even one pinch of opium cannot be, my lord, sold to outside. As per that, because in presence of police, it will be opened, it will be utilized, it will be sealed, everything procedure is there. what has happened, one FIR was registered against Rajnikant Patnaik, one person. My lord, from him, my lord, 10 kg of opium was seized. In the FIR, my lord, nothing has been, my name was not found place. Completely silent. Even if in the FIR, the statement was recorded, your lordship may kindly see the FIR. FIR, your lordship will find at page 82.
Page 82.
My lord.
Yes.
Lordship straightway come to 86. My name is not found place in there.
Yes.
But here, my lord, it is stated on sustained interrogation thereafter. My Rajnikant, the contraband articles were seized and he was interrogated. It is mentioned there. On sustained interrogation.
Where are you reading?
Page 86. On sustained interrogation thereafter, the detainee Rajnikant Patnaik, son of such and such village, Badalanda side, such and such, voluntarily disclosed that they have procured the contraband ganja from Bapi Dikal, Ajay Digal of Valikuda, Kandhamal. They have not been examined, they have not been even made accused. However, I recorded his statement under section 67 of NDPS Act in presence of the available patrolling party staff and independent witnesses. On further interrogation, the detainee Rajnikant Patnaik could not give any satisfactory answer toward the possession of huge cash and all the items. But nothing is whispered against the present petitioner in the affair and by the Rajnikant Patnaik in favor of the present petitioners. But my lord, subsequently one story has been developed that he has, my lord, brought my lord excess opium from government and sold it without having a receipt. That is the statement of other witnesses. But that is not the case of the PMLA. Rather, PMLA complaint was lodged that within this 20 kg, he has procured since 10 years and he has got the
PMLA is in different pedestrian altogether.
Yes. And what is the my lord, you will also may kindly see for the complaint. Even if the altogether, they say that the IT income tax which we have, my lord,
all these things, can I go into all these things at this stage?
But your lordship will go through. I will give the, your lordship. It is posted. It has to, my lord, required for the hearing. Your lordship, it is to that is for framing of charge. It is posted for.
Let it be, but in a PMLA proceeding, how can I quash all these things by going into everything? It is.
If at all, my lord, from the offence committed, if that property.
You are not challenging the predicating offence. You are challenging the PMLA proceeding.
Yes.
PMLA proceeding.
PMLA proceeding.
So the predicating offence, PMLA has to go on. What can I do? If I can understand, if you have challenged that you have read out the predicating offence FIR.
Right, but that is not.
You have not challenged that.
That is not posted for charge.
Whatever that you have not challenged. If that offence remains, then PMLA is the consequence. What can I do?
My lord, what my lord, I suggest to your lordship, it is posted to tomorrow for framing of charge, for last charge. Your lordship may allow me, my lord, to take a.
No, I can't do that. This is a very dangerous trend. I can understand if you challenge the schedule offence. Schedule offence you have not touched.
No, schedule offence, my lord, I have challenged. I have said that
in this proceeding you have not challenged.
It is, my lord, it is the.
You tell me schedule offence is state. Schedule offence is going on at its own
pace. It is not gone, my lord. It is stopped. It is stalled. For the reason, my lord, because the one of the accused, my lord, is in custody in PMLA.
But that is still going on. So it is the PMLA proceeding is a consequence of that. If that survives, it has to go on. I can't help it.
That's true, my lord. That's true. But fact remains, I must apprise to your lordships. If the complaint which has been, my lord,
you have read it out to the schedule offence. Schedule offence, you are trying to make out a case. Even if schedule offence is not made out.
Even if
can I go into a PMLA proceeding that schedule offence is not made out?
Your lordship may kindly see the complaint. Your lordship may kindly see the complaint.
Yes.
Annexure 1.
Annexure 1, yes.
Case 20, your statement, your lordship may comment.
Yes.
Case 20. That is the facts leading to complaint as per FIR.
Yes.
And your lordship may second paragraph.
Yes.
During the course of proceedings, the detainee Sri Rajnikant Patnaik voluntarily disclosed that he had procured the contraband ganja from Bapi Digal, Ajay Digal and F. Patnaik and others of Baliguda, Kandhamal. However, he could not provide any satisfactory answers toward the possession of such huge contraband ganja opium and cash and gold and gave.
That is regarding the schedule offense.
Schedule offense. Now your lordship may kindly see PMLA. Regarding PMLA, your lordship may PMLA. Your lordship may kindly come to para 7.4.
7.4.
Yes. Just my lord regarding.
I'll pass it over. Call Mr.
Therefore,
Agarwal.
my lord, I am submitting, my lord. It will take time, my lord. It is before vacation. Your lordship may immediately after vacation, your lordship may put it. Only one adjournment, your lordship may grant. Only one adjournment. Thereafter, my lord, I will.
You can move application pending is there. Then
it is posted.
And you bring Mr. Agarwal.
Your lordship may
I'll pass it over. I'll just bring.
Your lordship may keep it to first week of January. I will bring.
You bring Mr. Agarwal.
No, your lordship may do one thing because he is appointed as a additional government advocate in state also. But it will be very difficult to bring him.
These are ED cases.
ED cases.
PMLA cases. I will not stay. Come on.
I am saying stay, my lord.
The law is very clear.
I am not praying for stay.
This is indirect stay you are asking. So that
one.
What I am suggesting, call Mr. Agarwal. I'll suggest him that the prosecution will make this thing. Bring Mr. Agarwal.
After.
So that is why I am saying.
I
am just passing it over. Ask Mr. Agarwal to come, and we will. On record, I can't pass ST.
Yes, your lord.
But I'll ask him not to proceed there. Simple. Yes. I'll just come. Conditions.
Conditions, Miller.
You want that he should move application for variation of the condition.
Furthermore, the condition, it was modified thrice. And lastly, it was rejected also in that court. Miller 436A, power is not absolute, Miller.
Yes.
The Honorable Court has to.
In which case you have not undergone more than 7 years?
In all the cases, because we have taken to custody on 13/11/2017. So from that day, the
13/11/2017,
Milord. So I have given in custody date, the same date is custody. So then remanded time to time in
what is the release on bail means order of release.
That is one is 15/5/2019, then another one 11/9/2019, Milord. That is item number 3. 2 occasions, 2 bail 3 cases, 5 cases, 2 times order has been moved before the honorable court, and the honorable court allowed with the conditions. One is, my lord, in the first case 3 lakh, then reduced to 2 lakhs, then thereafter he is not able to comply.
Let us go one by one. Item 1.
Item 1. Item 1, Milord.
It was direct 3 lakhs was supposed to be deposited.
Milord.
You move application and then it reduced down to 2 lakh.
2 lakh, Milord. He is unable to
and
pay.
You are in custody since
13/11/2017.
Very 13. Where
I said custody. I have written that custody.
Acha, custody. Yes.
Milord.
And second, next item 65,000.
60. Milord. 65,000. Then coming
and reduced to 40.
40.
Yes.
Third one is, Milord.
And 4 lakhs.
4 lakh.
Reduced to 2 lakhs.
2 lakhs, Milord. Then next page, Milord.
Next page 1,15,000.
And then reduced to 57,500.
And 7 lakhs 50,000 reduced to 5 lakhs.
5 lakh, Milord.
5 lakhs.
Milord.
And what about the other one? Same, 2 copies.
2 copies I have given as per the lordship.
What do you say?
In many cases, the condition have been imposed by this honorable court in bail order. They could not fulfill it, remaining behind the bar. They will come up with to exercise the section 482. A similar matter was also filed to the item 51. The condition was imposed, your lordship sent back to the.
But he is challenging the these order.
Order 436. My humble contention is that 436A bail order challenging 482 will not be there.
Leaving the technicality apart. Leaving technicality apart.
Miller.
What do you say about his liberty? 7 years he is in jail. Despite the fact that the High Court has granted bail. He is not able to pay the money.
Miller.
And he is there in the custody since, see, he is not able to pay 40,000 rupees also. How many days you will keep him inside?
That is one aspect, my lord, but the Honorable Appeals Court has held that in economic offense, the court has to fix the has to take out the
Supreme Court also said that
interest of the victims.
but that's right. Supreme Court has also said that these conditions are onerous.
Onerous, yes, listen.
Taken 20 crores and twice it was
20 crores? No, no.
Total
it may be 45 lakhs altogether.
Rejected.
I think
once the condition was rejected, and if the lordship will release, then the bail order will become the redundant.
If I'll not release, then what will happen?
Milord, he will seek for higher forum for modification of the.
He'll remain for 10 years.
Maximum limit is 10 years.
See, forget about technicality. The liberty of a person is much more important than anything else, according to me, subject to what you say. And 482 to meet ends of justice, I can pass this on.
That is true, but 436 challenging the bail order. For that 482 jurisdiction is limited. Because tomorrow one will come challenging 439 application. Rejection 439.
I will say that it shouldn't have a precedential value. That much I can say. If you want to file any reply, you file it. इसके साथ लगाइए and file a reply. ठीक है? I'll pass the order. Yes, oblige. Pass the order. And you also give some judgment.
Miller. Yes, Miller.
Because what he says is
Miller.
Allowing this application is tantamounting to reviewing the order of the bail.
Miller.
And if the modification of the order of bail has to go to a respective court.
Miller. I understand.
You don't have assignment. That's what he says.
Miller.
And 436.
So we have to overcome that also.
Miller.
436 is not applicable because of the fact that he has been released on bail.
Now, this is another.
I understand, Miller, because I will give it.
He was directed to be released, but he is not released.
Directed to release, but not released.
It says the court shall release him on bail.
With or without security. That is also stated. That with or without security. Because of security is high, that is why we have come before.
So I'll pass your. I'll pass. You file a written note. You also file written.
It's also the right.
Yes, it is very clearly stated.
That's right. That's not. It's not an absolute right. It is not like 167(2).
Default.
It's not like that.
No.
It's not like that. So therefore, the court has to take the overall view and.
In computing the period of detention under this section for granting bail, the period of detention passed due to delay in proceeding caused by the accused be excluded.
Okay, I'll pass you.
So whether the proceeding has been stayed in this.
I'll deal with it. You give a written note. You also give a written note. I'll deal with it. Yes. Judgment register. Yes.
21.
The input note is annexed to 2 million. Let's see, can see the page 15. The complaint case has been dismissed on the ground of premature manner. The court, learned magistrate did not take any cognizance manner. The learned magistrate did not take any cognizance due to premature manner. This is a case of 130 NA Act manner. Relying on the decision of the Honorable Appeals Court 2000 Supreme Court manner, that is manner Narasingha Das Tapadia, that decision has been overruled. I am citing the decision of the 3-bench decision of the Honorable Appeals Court manner as well division bench.
Nursing that is overruled.
That has been overruled. Man. Fast motor. Jogendra Pratap Singh, the Lordship can see the Jogendra Pratap Singh decision. That is larger than 3-bench decision. The Lordship can see the page 38, paragraph 38. Man.
1 minute. Petitioner is agreed by the order dated 18/9/2024, whereby his complaint under section 130 has been turned down. As premature. The learned trial court has relied upon the judgment of Nursing Das Tapadia reported in reported in 2000 versus Govardhan Das Patania reported in AIR 2000 SC 2946. Next, then counsel for the petitioner submitted that the nursing Das Tapadia Supra judgment has already been overruled. He has also relied upon two judgment in support of his case. Issue notice to opposite party, written.
Can I pray one thing, my lord?
Yes.
Can I pray? The initial stage, the matter has been dismissed, my lord. The able lordship dispose of the matter, directing the I will file as per the order of this honorable order of the appeals court, my lord. I will file the application before the land. That is the observation of the appeals court, my lord.
Acha. Issues of no counsel for the petitioner submits that he would move appropriate application with the trial court, relying upon the judgment Supra to revive his complaint petition. The petitioner is granted liberty to move appropriate application before trial court to recall to revive the complaint petition before the court will. With this liberty, the petition dispose of. Yes. Move application. Yes.
27. May I please, Your Worship? May I please, Your Worship?
Yes.
That my lord, here in this case, my lords.
Yes.
Here in this case, my lord, the petitioner is challenging the order 9/5/2024, my lordship, under annexure 5.
Yes.
Page 39 to 44, my lordship. That the order dated 9/5/2024, my lordship, the London trial court granted the 143A of the petition of the complainant, wherein he allowed the petition for 20%. The amount that the present petitioner is challenging the same, my lordship.
Yes.
That, my lordship. That here in this case, my lordship, there is sufficient ground in my favor, my lordship, to prove that is a false one. The case was false one. Firstly, my lordship, that the cognizance taken after that the petition was filed after 12-day delay, my lordship. Without condoning the delay, the Lord Master take the cognizance, my lordship.
Yes.
That my lordship, kindly have a glance. The page number 12, my lordship, the legal notice.
What is this order?
That order is that the 5% of the amount, said amount, 9 lakhs. I am ready to face the trial, my lordship. I am showing the sufficient ground, but this is the difficulty.
5% only, 20% to 5%. What else you need?
Both the, my lords, the complaint is not come with clean hand, my lordship, because
whatever.
My lords, that
see for 20% you are supposed.
It is not a single case, my lordship. Already one case already filed against the present petitioner, my lordship. They are suppressing the matter. Then when the 143 petition of that case is rejected, then he come file this case, this present case, and again file the 143 petition.
Yes.
That's why I'm ready to face the trial. I'm ready to show my ground.
What is the option left for you? You have to face the trial.
Yes. That is sufficient ground.
Pay 5%.
Because that cognizance taken.
20% is mandate in the law. And the court has asked you to pay 5%. That also
the liability is not made out against me.
That is a different story. You have to
contest. The liability is not made out against me.
No, that is a different story.
That's why, my lordship, I am pray to pay the trial and showing the grounds, my lordship.
Simply issue notice.
My lordship.
Yes.
Oblige, my lordship. 42.
May I please, my lordship, my lord? My lord, the subtle point of lordship would be the learned magistrate issued statewide distress warrant for non-payment of maintenance amount without following procedure established under law. That is, my lord, that any order of maintenance for recovery maintenance under 25(3) has to be the condition precedent is 421 of CRPC. Yes. That has not been followed. That is the subtle point. Apart from that, the matter between mother and son.
Where is that order?
Yes, order is, my lord, my lord's kind attention to the order. My lord, page 10, my lord. 10. Last paragraph.
Okay.
The area amount 36,000. I'm having on distress warrant without following procedure established under law.
This is 10, item, page 10.
Yes, 10 mil.
And 20th of May.
20th May of 24. Only last two line, my lord. States warrant to local police.
Hey, where is that?
My lord, last paragraph, 10 last paragraph, my lord. Last but two line. Hence issue DW against the opposite party number 1, the present petitioner, to the IIC so and so put upon the state warrant. So the state warrant ought not to have been issued without following, that is, my lord, the
area of 36,000 only.
36,000. Well,
what is the maintenance awarded? Maintenance awarded?
Maintenance is awarded within 20 million. The area amount, area maintenance under 25 through has been persuaded to. That is million. Your notice government, there is, I hope that father and son, mother and son
Hey, what is the maintenance amount?
But this petitioner 36,000 and our other son, OP number 2, 36,000. So total 72,000 was awarded to the petitioner mother. He has two sons.
Go and move an application there.
I have made the application. RC will notice it would be holistical approach. There may be a
issue notice. Yes.
And we let 36,000 some deposit because this son has been staying away, and the entire property, mother and my
50% you deposit. 70,000, 72,000 is the amount total.
Yes, two order for 36.
So you pay, there are two petitions?
Two petitions, two order.
Where is that?
Yes. Then another is Milord, pays 12 million. That is for the period of 22. Pays 12 million.
12, huh?
And 36, so 72,000 has been awarded.
Item number 40? 42. Yes. 42. 12, huh?
Yes, pays 12.
Okay. 36 here also.
Yes. So two
subject to, there are two subject to petitioner depositing 36,000. Huh? The operation of order dated, orders dated of 4/5/2000, order dated 20th May 2024 and 7th October 2024. 24, na?
Yes.
2024, passed by JMFC in CMC number 2 of 2023. In CMC case number 125 of 2021.
Another
and CMC number 2 of 2023 is stayed till next date of hearing. Yes. Deposit. Issue notice. Yes.
On deposit of the
36,000 you deposit.
How many million?
In both the cases.
How many?
Within 1 week. Yes.
How much million?
Deposit within 1 week. 40?
54.
Yes.
May I please, my lord. Hearing, my lord, I am challenging one NBW dated 19th of February 2020, my lord. In the FIR, my name was not there, neither in the preliminary charge sheet. Rather, in the charge sheet, my name came into place, my lord. In the meanwhile, my lord, other accused person.
Order, which is that order? Order dated?
19/2/2020, my lord.
Where is that?
Lord, that is at page number 54, my lord.
54?
Annexure 6, my lord.
Yes.
Running page 56, my lord.
Yes.
Herein, my lord, at the instance of the request made by the IO, learned SDJM
the petitioner was not named in the FIR. However, charge sheet has been filed showing him as an absconder, and on the prayer of the IO or the SDJM article by order dated 19/2/2020 issued NBW against the petitioner. Petitioner is agreed by the same and hence has filed the present petition. Regarding it to the on instruction, petitioner submits that he would his client would appear before the court on 10th of January. Yeah? Regarding it to the statement made by the counsel for the petitioner, the NBW issued by the SDGM Kathagoda wide order dated 19/2/2020 exhibition of NBW is stayed till 10th of January. The petitioner is subject to petitioner appearing or surrendering before the court below on or before 10th of January and depositing rupees 1,000 in the High Court bar. High Court bar?
Yes,
High Court bar. Yes.
My lord, I was not in bail, my lord, because my name was came into place in charge sheet.
You argue, you move application. It is not bail court. Yes, next.
60.
Yes, Mr. Agarwal.
No copy has been served.
But he says that tomorrow the matter is fixed for charge.
My lord, whatever when he filed the application, he should have served me copy. Even I asked him.
Copy.
He is sitting here, is not serving me copy so that I could have asked my IO to give it.
See, I wanted to help you. You should have given an
But I
advance.
have copy. I
I
just wrote upon the
requested him,
central
then
central
also
government
he has not
office.
given.
No, why you are showing? Copy has been served upon the central government manor office, advocate's office.
He is handling all ED cases.
And
What can I do? Then put it on reopening day or what?
It is a 300 more than pages, your lordships. My lord.
But you have to give, see,
So it is.
these are PMLA cases, can't be stayed like this. Unless you serve and it is heard.
One of the accused in custody since 2022. Up to Supreme Court has rejected his bail application.
No, it is not my case. It is not my case.
It is a voluminous document of 333 pages. It has to be heard.
He is the co-accused.
Supply the copy.
Same case.
But I will serve a copy only, my lord, tomorrow.
Mr.
Adjournment
the
only.
petitioner,
I will serve a
directed to supply the copy of the petition to Mr. Agarwal. Mr. Agarwal leaves the matter after first week.
My lord, only my lord, the adjournment.
How can I do, sir, unless you satisfy? This is the PMLA cases are not to be stayed like this.
No, it is not stayed, my lord. I have said tomorrow is posted.
I told you
my lord, tomorrow
in the schedule offense you are not questioning. Schedule offense is
I
going
am
on.
questioning the
And these are consequential proceedings.
Only my ground is I am questioning the civil offense. Therefore, I am questioning the PMLA act. Unless my lord, I question the civil offense, I can't.
Where have you questioned? You have not questioned schedule offense.
Yes, I have questioned in that. That is.
Now, in this proceeding, you are only questioning the PMLA.
I have filed one application there saying that the no offense.
Therefore, I am saying if you are
no offense is made out in the civil offense against my because my name is not appearing in the affair.
But for that you have to resort to some other proceeding. I can understand you challenge that and tag with this. I can understand.
That stage has not come because the accused Rajnikant Patnaik is within the jurisdiction of the special court in the jail custody.
But I don't know what can I do. I
only
don't.
My lord, tomorrow, my lord, I seek only my lord.
What will happen? What will happen tomorrow? This heaven is not going to fall. You.
My lord, if tomorrow what will happen, my lord? If charge, it is directed that charge will be framed positively. Because
Then
one accused is in jail.
Show me that proceeding.
Yes, your lordship.
Show me.
That is it is positively it is said.
Show me that proceeding.
But it was your lordship may kindly see the informed order. In informed order, it was stated.
Where is that?
If my charge will be framed.
Then show me that it will be done positively.
Your lordship may kindly see 332, page 330.
332. Yes.
Put upon second paragraph. Put upon 27/11/2024 for consideration of the charge. But on that day, it was directed that I have filed one application that I am moving on.
You said that court says that positively framed.
Positively, yes. So, my lord,
it is for consideration of charge.
Yes, charge.
You argue the court of charge.
No.
Such a big matter.
Subsequently, my lord, on the there are.
Show me that
that order, my lord, I could not. I don't know. But it is said. My statement may be recorded. You lordship may make my statement, record my statement that it is stated.
What do you say?
My lord, it's a huge scam. Drugs, opium, silver, and I think around 8 kg of silver, cash around 1
It is against Rajnikant Patnaik, not my say.
Whatever, but see, consequences are.
Co-accused. My lord, I have no instruction because I had no copy. I could not know in which one. Suddenly, when
give a copy.
From name, I could ask my.
Give a copy. Put it tomorrow. Give a copy. Give a copy.
Tomorrow, my lord, it's not possible.
You just try. We'll see.
I'll try.
Yes, next.
61. What is your story?
Yes.
This is a Belgium matter, petitioner release on bail on 27/1/2023.
Yes, madam. Tell the date. Bail.
There was 27/1/2023.
Both the dates you tell, huh? For the 10th of January. Okay, 500. Yes.
Balance.
1 minute issue.
Bail was granted on 13/12/2019, my lord.
13/12?
2019, my lord.
Okay.
Page 8.
500.
My lord, MW issued on dated 6/11/2024 and the present petition released on bail on dated 11/10/2024 by the court below, my lord. By the SDGM Rayagada, my lord.
500. Yes.
Belgium matter, let's say, NBW issued on 14/8/2023, bail on 1/9/2016, your Honor.
500.
65, my lord. NBW issued on dated 2/12/2024, my lord. The present petition released on bail in BLPL number 8264/2024 on dated 3/9/2024 by this honorable court, my lord.
500. Yes.
NBW was issued on 2/8/2023 and bail was granted on 1/11/2009.
Okay, 500.
67.
My lord, the warrant of arrest has been issued, my lord, on 9/12/2024 under Annexure 3. Is a NI Act, my lord, only it was the 205 application was allowed earlier. 2017 years.
Petitioner is accused in the complaint case initiated by opposite party under section 138 NI Act. He moved an application under section 205 CRPC, which was turned down, and NBW was issued. NBW has been issued by the order dated 9/12/2023. Yes. 500.
68.
The Lordship is a Belgium matter, and NBW was issued on 22/10/2024, and bail was granted by this honorable court on 11/8/2021 and released on 14/11. 14/8.
69.
Please, Lordship. Belgium matter. MW issue on 1/12/2022. This is around 130 NI case due to non-appearance and below the issue.
And NI 205 लिखी होगी. Yes.
My lord, this is Belgium matter. The petitioner was earlier on bail on dated 17/5/2016 and NBW was issued on 28/9/2022.
Yes. 500.
71.
500 each.
May I please? The matter relatable to the incident relative to 96. In the year 96, they were granted bail, this petitioners. Thereafter, after charge sheet, the NBW was issued because there is non-appearance. And in fact, they have filed an application to recall the NBW, and the law and magistrate hold that because the NBW has been issued 18 years back, so I cannot recall it. They were on bail, your lords, admitted. And all other accused persons are now released on bail, and I have annexed those orders.
18 years when the NBW was issued?
NBW.
98.
My lord, 98 the NBW was because.
What are the offences?
440, my lord, there is offences under section 448, 294, 427, 323, all those minor offences.
98 bail NBW was issued, and you remain.
How many? Because the notice, after the charge sheet, the notice is sought to be served. Actually, we have left that place. We have left that. That is why the notice.
You are in bail, you are supposed to attend.
How could I know that? Anyway, your lordship, I was under a shop to attend.
Petitioner
order has been passed
in FIR in PS case number so and so. Charge sheet was filed in the present case on 10/9/1997. Although the petitioners were on bail, but for their default in appearing in the court on 21/4/1998, the which court is that? SDGM Bhubaneswar had issued the NBW. Well, and counsel for the petitioner submits that the NBW, the notice was neither the notice from the court nor the NBW was served upon the petitioners as they have changed the address. Subsequently, they moved an application.
On next page, your lordship, 17/9/21.
Application on
17/9/2020, plus 24.
Recalling up to the NBW before the trial court, which has been turned down by the impugn order dated 17/9/2020. Thereafter also 21 after 3 years you are coming.
Well, that's, actually, it came to my knowledge. My lord,
You have everything but except knowledge. Except knowledge, you have everything.
Because there are altogether
98 NBW issued, and after 18 years move application, that is rejected. Thereafter 3 years you are coming here.
Yes, that sort of negligence.
How much indulgence one can give?
Because the case will be regularized here.
Okay, you pay
4 cities here.
3 of you pay 5,000 each.
5,000 each, your lordship.
5,000 each. I would tell anything, 10,000. I'll make 10,000.
No.
5,000 each.
Your lordship,
Before Odisha High Court.
No,
nothing big. Otherwise, I'll reject it.
Page 32 dekho, tab se ठीक habo.
No.
32, 4 series dekho. Similar circumstances in the 2000.
Maybe. I don't. Maybe that.
All other accused persons in the similar situation.
Do whatever, but pay 5,000 each. 3 of you, 15,000 rupees. You pay to the bar because of your this thing. And then you will have knowledge thereafter.
That I am happy respect to your lordship's order. Your lordship have not.
Who will give indulgence? 18 years. Thereafter 3 years.
ठीक है sir.
I'll reject otherwise.
Okay. My lord,
Let it be executed. I give a direction that the NBW should be executed within 15 days. Reject it and I'll give that direction. You can't take court proceeding like this. Just see 18 years plus 3 years. 21 years. Yes. Go and appear. Yes.
Appearance shall be released on bail.
That I'll not say.
No, I'll deposit the cost, your lordship. I'll deposit the cost as your lordship.
Cost, you are not purchasing bail. If you are entitled, you will get it. If you are not entitled, you will not get it.
Well, I'll appear, your lordship. I'll 4 series of similar sort of bail.
No leniency to this thing.
After 20
no leniency to this. Otherwise, I'll not give indulgence.
Move.
Appear and move application. If you deserve, you get it.
NBW में आगुरु bail थी ना सेटले to continue on that bail.
No.
It may be rejected.
I will not do that.
And it may be rejected. The petition of ladies of 70 years old.
Maybe
this is
the way you conducted Jesse 97 FIR. You got the bail. Thereafter, conveniently, why? What is the bail? Bail is you are supposed to go and participate in the trial. That was the condition of bail.
The condition.
You didn't go. 98 NBW issued. Slept over for 18 years. Thereafter, move an application. That is also rejected. Thereafter, slept it for another 3 years.
3 years. 2 years, your lordship.
And why indulgence to these kind of people?
Ladies, your lordship.
Maybe.
They all are now.
Next item. Yes. Withdrawal, huh? Withdrawal. Okay. 72, na? 72? Okay. 73 withdraw. Yes, 74.
72. May I please? The petitioner is inside custody since 24/11/2023.
24/11/2023. Yes.
And, on the last occasion, the state was directed to verify that petitioner is on same footing of the earlier bail petition which were granted by my lordship to the co-accused person. That is, my lord, at annexure 4, the co-accused bail
Annexure 4,
application order.
1 minute.
My lord.
Yes.
Page number.
Yes, Mr. Jana.
Your lordship says granted bail to one Joy Chandra Singh.
Jai Chandra Singh. Yes, Jai Chandra Singh.
On the basis of your lordship also, in para 5 also stated that Sanjay
Kumar Bari, who gave the fatal blow to the deceased, and these persons were present at the time of occurrence. Only there was present.
And on the basis of Ramchandra Behra statement, my lord, your lordship says granted bail.
Prafulla Chandra Behra.
And Prafulla Chandra Behra application was your lordship says torn down. But this petition stands in similar footing with that person. I'm placing that paragraph particular. ତାପରେ ଯୋଜନା ମୁତାବକ ସଞ୍ଜୟ ବ୍ୟାଗ ଭିତରେ ଲୁଚାଇଥିବା ଏକ ଲୁହା ରଡରେ ଚିତ୍ତରଞ୍ଜନ ବେହେରାର ପଛପଟ ମୁଣ୍ଡକୁ ଜୋରରେ ବାଡେଇ ଦେବା ସେ ତଳେ ପଡିଗଲା। ତାପରେ ସଞ୍ଜୟ ସାଙ୍ଗେ ନେଇଥିବା ଏକ ଧାରୁଆ କଟୁରୀରେ ଚିତ୍ତରଞ୍ଜନର ବେକକୁ ଶୁଣ ସାର୍ ଥରେ ପ୍ରଚୁର ସାର୍ ସଞ୍ଜୟ କହିବା
The who para 5 video, the order dated Onishi, co-accused Jayachandra Singh had filed BLAPL number 5238 of 2024, which has been allowed by this court by the order dated 19/9/2024. The para 4 and 5 of the said order is relevant to be reproduced. 4 and 5 reproduced. Para 4 and 5. Next paragraph. The role of the petitioner is similar to that of the co-accused Jayachandra Singh. He has not participated in the commission of offence. However, he lended support to the prime accused Sanjay Kumar for destroying the tooth for disposing of the dead body and disposing of the dead body and destroying the evidence. The petitioner is in custody since 24/11/2023. Regarding to the period of custody and the fact that the co-accused has already been enlarged on bail, who is similarly situated, and the petitioner's role the role attributed to the petitioner is regarding the disposing of the dead body and destroying the evidence. I am inclined to enlarge the petition. Yes.
75. Some witnesses examined below. So pray for after vacation.
Okay, after vacation.
I would supply the request.
Bring those. Yes.
Obliged.
6.
Call for CD. Next vacation. 77. कितने बिल लगा दिए भैया? हाँ 77.
The non transport reject the bail application on the ground, the material witness has been examined, Your Honor. 30 days, 30 Your Honor. The rejection order.
Yes.
But material witness, including informant, are yet to be examined. Therefore,
after week. I'll put it after second week.
Yes.
Second week.
77, 78, 79.
Yes, sir.
All the three after immediately after vacation.
The witness eyewitness has not been examined.
Eyewitness another Tirnath Huya. He has not been able.
So I'll take it up second week. Second week I'll take.
Milords, your earlier order you have given, Milords. Out of them, I have given all the.
I am simply adjourning it immediately after vacation. By that time, some witnesses may be examined.
In the meantime, I have given 11 witnesses have been examined. Out of the list, your lordship earlier directed 4 persons. If your lordship pays para 4, your lordship will kindly mark. Your lordship said Narayan Gowda, Lamodar Pradhan, Mukesh Swai, and Tirnath Bhuya. First 3 have been already examined. I have given the copy. Just
important.
Let me finish it.
Yes.
And then your lordship lastly directed there are recovery of weapons. These 2 witnesses have also been examined.
I'll just take immediately after vacation.
No problem.
I'll just keep it like that.
We have remained there for so many years, so another 1 month.
2025 will be good for them. 2025 will be good. Yes.
80.
कितने बिल लोग थे भाई?
In the last occasion,
80.
Council for the state was directed to obtain the instruction with regard to CML.
Yes, have you got instruction?
So has been.
Awaiting instruction. Council for the state seek last opportunity. Release the matter after vacation.
Already a charge sheet has been filed.
Let him get the instruction. Yes. 81.
81.
That is 42C of the NDPS Act.
I am in custody since 9/7/2023.
9/7/23.
2023.
Recovery, how much?
Recovery, my lord, your lordship may kindly 8 bags, different bags, poly bags, and in one motorcycle, 60 kg some odd. So your lordship may kindly turn to your lordship's order, page 31.
Yes.
Second para.
Mm.
Firstly, the recovery is about 60 kg 400 grams insofar as the present petitioner is concerned. Secondly, the concession of interim bail.
420 kilo.
420 in all.
Hmm.
But from each motorcycle, 60 kgs, 400 grams.
Okay.
And in the meantime, my lord,
How many motorcycles were there?
8 motorcycles. Your lordship may, it is revealed from the FIR, page 12.
Yes.
After reach the spot, we noticed the 8 poly bags have been loaded in four motorcycles.
4
2
motorcycles.
poly bags have been loaded in each motorcycle bind with so and so, so and so. My lord, apart from it, my lord, 38 out of 38 witnesses, only 10 witnesses have been examined and 10 witnesses have been declared hostile.
All the 10.
Yes, all of them have stated categorically that nothing was seized in their presence. That has.
Oh, that matter. Okay,
Yes,
okay.
that-
I understood. The exhibit.
Yes.
Have you got it? Oh, where is that? Depositions?
My lord, deposition I have annexed. Your lordship may kindly turn to
Yes.
page 20.
Yes. Have you got any? I will not adjourn this matter now.
Page 26.
3 times, 4 times I have adjourned only to get that instruction. The exhibits are related to the recovery or not. You want to get instruction.
It's been seized your contraband ganja has been seized. Proceed from the exclusive position of that in there. In the
What I have asked, what are you? Then I'll write that no instruction is coming, I am granting bail. Last time I told you, I'll record that state council is not able to assist me, therefore I am granting bail. I told you in this matter only. You give me that letter, I'll reproduce and grant the bail. Let it be like that. What is this going on? Somebody is in custody, you people are taking so lightly. Give me that. If the IO is not interested, why should you? Just see. This is very unfair. Who is this IO? Right. For the, I'll see, ask the IO to be present in person.
My lord, then lordship keeping it to tomorrow. My lord, I am.
Tomorrow you may not come. First day. Reopening.
My lord, I have filed a petition for interim bail because the wife of the petitioner is in advanced stage of pregnancy. I have filed all the documents. It is with your lordship.
Show me.
Yes. That is, my lord, IA number 1487 of 2024.
IA number?
1487.
Okay, what I'll do is I'll grant interim bail.
Yes.
And recording all these things, and you apply for. The petitioner is agreed by the order dated. What is that order? Order dated. When was your bail rejected?
Dismissed, my lord. That is.
Marital.
My lord, 12/8/2024.
Marital.
12/8.
Petitioner is agreed by the order dated 12/8/2024, whereby his bail application has been turned down by additional sessions judge, Special Judge Pulwani in city case number 100 of 2022. Next one. Petitioner is an accused in FIR number so also. Allegation against the petitioner is so also. The Mrs. Sujata Jana, lead counsel for the petitioner, submits that out of 38 accused witnesses,
Only 10 have been
38 witnesses, 10 witnesses have been examined, and all the 10 witnesses have turned hostile. She has taken me to the evidence of PW 1, 2, 3, 1, 2, 3 specifically. Specifically, all the 3 witnesses are the witnesses to the seizure, witnesses to the seizure, and of all of them in unison have stated that nothing was seized. Nothing was seized in their business, and they refer to the exhibits, various exhibits. For ready reference, a statement of PW 3 is reproduced, page 28, para 2. Para 2. All other witnesses, those who have been examined, have deposed in the similar manner. This court, by the order dated, first order dated, 1 minute. Order dated.
Order dated is 26/11/2020.
Order dated 30th August, 30th October 2024, directed the State Council to seek instruction in this regard. Subsequently, on 26/11/2024, specific directions were made to the State Council to seek instruction regarding the testimony of the 3 witnesses, those who have categorically stated in their evidence that they were not they have not seen the article. The seizure has not been made in their presence. The exhibit they referred to by the witnesses, whether it's related to the seized contraband or not, was required to be obtained from the IU. Then Mr. Mohanty, learned counsel for the state, submits that he has written letter. He has written 3 letters dated 27/8/2024, 24/9/2024, and 18/11/2024 to the Superintendent of Police and the IIC of Gochapoda Police Station, Kandhamal, for furnishing the instruction. However, none of the letters written by him has been hid by the either by the Superintendent of Police or the IIC Gochapoda Police Station. This attitude of the all the letters are the Superintendent of Police and the IIC Gochapoda is deprecatable, and this court doesn't approve of the same. With the State Council instruction, it is the duty of the Superintendent of Police to furnish the information forthwith, particularly in the bail matters, as the liberty of the citizen are at stake. Be that as it may, at this stage, I'm not passing any adverse order against these officers. However, the copy of this order may be sent to them to remain alert in the future cases. At this stage, Mrs. Sujata Jena submits that she has moved an application for grant of interim bail to the petitioner on the ground that the petitioner's wife is at advanced stage of pregnancy, and she has also enclosed various documents in support of the same. Taking into consideration the fact scenario of the present case in entirety, I am inclined to enlarge the petitioner or interim bail for a period of 4 weeks.
4 weeks or one.
For a period of
For 3
8
months.
weeks. 8 weeks.
Because 23/1/25 is the due date of pregnancy,
Eight.
delivery.
8 weeks. 8 weeks. 8 weeks. The petitioner is already in custody since 9/7/2023. 8 weeks, which is it. So, in view of the next follow, insofar as the main bail plea of the petitioner is concerned, Mr. Sujata Jana seeks to withdraw this petition to file a fresh petition before the trial court, and the trial court is expected to deal with the same in the light of the evidence which has come on record. Because you people will not get in, at least you can raise all this thing there. Hon'Ble?
The trial court is expected to take which is common before.
Come on record. Okay. The liberty is granted to the petitioner to move regular bail application to trial court after after the expiry of the interim bail period and surrendering before the court. Okay. You surrender and jaldi
My
kar
lord,
do.
next one, 2 matters are there, 81. Next matter is basing only co-accused statement. He was taken to
The same FIR.
same affair.
Or in that case, same witnesses, same everything same.
Everything same, and he has been taken into custody on 13/8/2024. Although, my lord, the charge sheet was submitted on 5/1/24, only on the basis of the co-accused statement, he has been taken into custody.
Okay, 81 na?
81 the
82.
sub item.
FIR is same. Sub
FIR
item
same.
इसमें personal appearance लगाओ इसका IAC personal appearance.
81 sub item.
81 sub item personal appearance of IAC. Let him come.
And nothing has been seized from his conscious project.
We'll see. Let them come once. Yes.
Oblige, your lordship may.
In second item, the IAC is to present in the person report.
Not filed in the meantime.
No, let him come. He has ignored 3 of your letter. What is this going on? 1 letter is enough. First letter he should have.
My lord,
See, otherwise they will not bother you. Let them come. Let him come.
lordship keeping it to
First week.
first week.
Yes.
Oblige. My lord, 82.
Yes.
82, it was also heard by your lordship earlier. Trial,
Same.
no, my
Same
lord,
FIR,
not
it's a
same
different-
FIR.
Yes.
My lord, he 20B2C, custody since 14/4/2023.
Yes.
My lord,
Recovery. What is the recovery?
my lord, recovery 150 kg, 995 gram. My lord, the main accused fled away from the spot, and he has been, my lord, 2 witnesses in the meantime has been examined. If a lordship will.
Yes.
2 witnesses has been examined.
Yes.
Lordship may kindly see the first witness number 1, the main driver of the vehicle has fled away from the spot. The co-driver was apprehended and he was brought to near the offending vehicle. He was brought near the offending vehicle. Then your lordship may kindly.
No, he was the co-driver.
Petitioner is the co-driver.
But recovery is from him.
Recovery is from the vehicle. He was not there. Your lordship may kindly turn to witness number 2.
Yes.
Witness number 2, para 7. Para 7, you lordship may skip para 8. We are not present at the spot when the offending vehicle dashed the electric pole, nor we have seen it, but we reached at the spot after the vehicle dashed the electric pole. The electric pole was bent and it was iron. The offending vehicle was also damaged due to such dashing. I do not recall whether any broken glasses so and so, your lordship may then para 9. when we
No
reached-
person was found in the vehicle
Yes,
or at the spot.
yes. And when we reached near the vehicle, no person was present inside the vehicle nor at the spot. We apprehend the accused Bhim Singh at a distance of about 100 to 200 meter from the vehicle. My lord, this is only two
He
witnesses.
had sustained some injury.
My lord?
This petitioner has sustained any injury?
No, no. But he is in custody, my lord, since 14/4/23. And 9 charge sheeted witness, only 2 have been examined.
Let's check it up. Do you have this? Oh, third. Yes.
Obliged.
83.
CD is not available in this case. Everything is there on last occasion leadership.
CD?
CD, charge sheet, everything is there last occasion for the specific matter, last occasion director matter.
Just check it up. Soroj Mohanty.
The available says long when I was there, side matter also CD. will be there. ସବୁ ଥିଲା hearing ରୁ ଦିଟା ବି ହେଇଛି appropriate ହେଇଛି
Third or fourth. Connected matter if you have.
ଗୋଟେ single charge sheet submitted.
The Tej Pratap then comes for the state submits that he has not received the CD in this case. Release the matter immediately after we review this. See.
I ବି instruction ଦେଇଥିଲେ କେସରେ ଆସିଥିଲେ ହାଇୱେ ଆସିଥିଲେ ପ୍ରେସିଡେଣ୍ଟ instruction ଦେଇଥିଲେ କେସରେ.
Just see you might have kept some.
Today also I was present. I was present outside. I have occasion.
Interesting thing is he knows more than you.
Since I am that side, I know the IO.
He knows the IO also. He is still in contact with the IO.
420. No, dekhi takwa. 420.
Check it up and.
So let it come after.
Yes.
I dekhi.
Third or fourth.
Your Lordship, offense under section 376(2) and 384(506) of IPC, read
Yes.
with section 66E.
Custody,
Your Lordship, custody since 9/11/2023.
9/11/23.
Yes, Your Lordship. In the meantime.
You are there for opposing. Huh? You are not appearing in this matter. Okay, you want to mention. Okay, wait. That settlement matter. After this matter, I'll take it up. Yes.
Your Lordship, in the meantime, the victim has deposed before the trial court. I am placing reliance on deposition of the victim.
Yes.
That is annexure 4.
Come to that.
In the annexure 4 is 41 cross examination.
What is the age of the victim?
Age of the victim is 36 years. And the petitioner is 27 years old. Your Lordship, in para 15 of the cross examination, it can be seen that they know each other. The victim and the petitioner know each other.
She's cousin.
They are the cousin.
Her cousin.
And in para and in para 20, after the occurrence, after 8 months of the occurrence, the FIR has been lost. My submission before Your Lordship is that the matter came into the knowledge of the family member of the victim. So this case has been forced against the petitioner.
Because of the viral of the photo, my lordship. Because of the viral of the photos. That's why they find that.
From the prosecutory evidence, what are you going to draw? She has very clearly GSC para 2. Very specific, para 2 and 3.
And in the final form also, I was given.
Your Lordship, my only contention is that since 10,000 has been asked by the petitioner, and after being refused, the the petitioner made the photos viral. But prior to that, 70,000 has been paid by the victim to the petitioner.
Where from you are getting all these things? From evidence?
No,
You built up some story you are telling. From the evidence you, where is the suggestion you put to this prosecutrix?
No, your
10,000, 7,000, all these things.
Your Lordship, in para 16 of the cross-examination.
No, 13. Para 13, come to para 13. My son and daughter are studying at the rest of.
Approximately 10,000, and that is the passbook. Prior to the occurrence, I had paid 70,000 to the accused.
13. Whatever he's saying, just see.
That was the session. I don't remember.
And rather, you have taken 70,000.
Yes.
My humble submission before
70,000. That's why he viral the photo. That's why this case.
You have not only raped her, started asking money.
Yes.
70,000 you have taken. Once you asked for 10,000 rupees, she didn't pay you. Therefore, you viral.
Yes.
This is the evidence.
my humble submission before your Lordship is that since the matter came into the knowledge of the family members of the victim, so this case has been registered.
Sir, the story will not work. From the evidence you show me, you built up some story you want. How the evidence you have to show me? These are those things. Maybe see the phone number and everything is there.
Yes. And they have seized also, my lordship. The photographs they have seized in the seizure used.
No, I don't think you have. I'll just say urgency. I think you are not prepared properly. Prepare properly. I'll just simply urgent. Instead of rejecting, let us.
Yes,
He is not prepared properly.
yes, ma'am.
Second week, second week. Prepare properly and come.
Yes,
because whatever the story you are saying, you should have put it to the witnesses. You have not put it to the witnesses. Then at least suggestion or something.
Yes.
Yes.
Obliged, your Lords.
Go on. No, I have already passed.
5,000, 5,000, 5,000. Your lordship.
That's what I said. I have not said
It's
anything.
passed that order.
I have not said anything. I have simply said that you deposit and it is recalled and go and appear and move application. That's all. Nothing else. Yes.
Obliged.
Yeah. Yes. Come. Yes, madam.
My lord, 110, my lords, I'm there on VC, my lord.
Yes.
It's an application, my lord, both the parties have entered into compromise. And in the CRLMC also, my lords, there is an application filed by the complainant in a bail application that she doesn't want to pursue. Then your lordship was of the view that both the parties should come up and file an affidavit. Therefore, the affidavit is ready and both the parties are also there. The complainant as well as the petitioner.
Charge sheet has been filed.
Well,
Yes.
well, yes, my lords.
Charge sheet filed?
Yes. Charge sheet filed.
Cognizance is taken, huh?
My lords, basically arising out of a civil dispute, my lords. There's a suit also pending and both the parties have now decided.
What is the stage? I just want to know. What is
Yes,
the
yes. Charge sheet has been filed, my lords. And so far as one of the accused is concerned, my lord, trial had begun. But so far as this petitioner is concerned, your lordship had said state proceeding.
No, how many accused persons are there?
My lord, so far as the present CRLMC is concerned, my lord, there are 3 petitioners, my lord.
I'm asking something else. How many
9
accused persons are there in this case?
My lord.
9 accused persons.
9 accused persons.
Yes.
You, the prosecutrix has settled the dispute with. No, it is no. This is 323, 379 and all. See, the opposite party has settled the dispute with whom? All of them?
No,
Yes, my
no.
lord, because they say because the opposite party says that she doesn't want to proceed with the complaint at all.
But why the other accused persons are not there today in this matter?
my lord, so far as the present petitioners have, they have, my lord, decided to file this particular case, my lord, CRLMs.
No, that won't happen. Either you settle the dispute fully or don't settle. Where is the charge sheet? Show me. Show me the charge sheet. Charge sheet.
Page 77.
77?
74 of it.
94. Relevant page is 92.
Just check it up. How many accused?
Four petitions.
I'm asking
Important
accused.
four.
Total accused in charge sheet. Total accused in charge sheet.
Total again 4. Padmanabha Mahapatra, Dolo Govinda Mahapatra, Ashish Ranjan Mahapatra, then Sasmita Mah.
In charge sheet.
Charge sheet.
Sasmita Chari. Okay. And who are the petitioner?
Petitioner here Padmanabha, Dolo Govinda, and
Sashmita Mahapat.
Sasmita Mah.
And who else remained?
One
Mahapat.
Ashish Ranjan Mah.
He's acquitted.
My lord, so far as Assis is concerned, trial had taken place and he has been acquitted. My lord, the evidence has been also taken place. I have the certified copy is also there.
Where is that? So give me.
The certified copy.
And these people were absconding.
My lord, these people had filed in bail applications. Thereafter, there was an order, my lord, which is also on the record. Thereafter, the CRLMC was filed and your lordship had passed an interim order.
Yeah. Give the affidavit. See the injury report. Injury. Show me the injury. That is the instance of opposition. Party number 2, FIR number came to be registered against the petition. After investigation, you have shown the charge sheet. Yes, after investigation, charge sheet was filed in the present case on injury report. Show me. Charge sheet was filed in the present case on 30/12/2021 for alleged commission of offences punishable under section 341, 294, 427, 379, 34 IPC. 34 IPC. That's against a Polish. Against Polish. Yes. Against Polish. Yes, see the charge sheet was filed for offence under section 341, 294, 427, 479, 34. And whereas the order shows that it is 307.
307 is.
Show me the cognizance order at least.
Yes. This them.
Hey, it is the charge sheet case.
Yes, Mr. Marana.
My lord.
What are the offences? The charge sheet is filed for different offences. Cognizance is taken otherwise.
Yes, my lord. Your lordship may kindly see the FIR. Your lordship may kindly see first.
Come to the charge sheet. I am there in charge sheet, page 28.
Yes, my lords.
None of you have prepared it.
My lord, the charge sheet, my lord, that is there, my lord.
Please sit after vacation. Please sit after.
My lord, that
You don't read and come and.
that is
Please sit
filed by
after.
someone else.
Next. Please sit after vacation. So 119 urgent. Yes.
My lord, interim to continue. Interim to continue.
Yes. Next. You prepare and come. What are you doing? Charge sheet is filed some other offence. Here it is written what 307.
If I may be permitted, my lord, that FIR was lodged by
Don't,
someone else, my lord, not
come up
related
with-
to this offence.
Then why have you filed the? You are saying charge sheet.
My lord, that
Page
was-
28 is something else.
that FIR was filed by the petitioners, my lord.
I don't know. You prepare and come. I can't struggle to get what are the offences and all.
Oblige, lord.
86.
May I please, your lordship. Lordship, I filed a application for restoration, your lordship.
Restoration?
Yes, your lordship.
Delay, how much?
Delay of 557 days, your lordship.
2004 matter, my lord.
And the
Which is
restoration,
disposed of on 2018.
your lordship.
2014 present CM appeal are being filed.
Do you have any case on
Yes,
credit?
yes, there is. They have in their counter, they have given that their petitioner is entitled to a due of some 87,000.
Show me the sufficient cause.
Counter, that is the whole thing. The counter,
No,
in the
no,
counter,
condonation of delay. Cause.
your lordship.
Condonation of delay.
Condonation.
Ground condonation.
Ground, we were unable to trace him. As a result, when he came, we filed it. That is the ground, your lordship.
Let them pay subject to paying costs. Right. The IA 52 of 2020 for the reasons stated in the application, the same is allowed. The delay in filing CRLMP is condoned subject to petitioner paying. How much you will pay to bar?
So he doesn't have a job. Your
2 years
lordship.
delay.
Yes, your lordship.
Pay at least 5,000 to
1,000 can't pay. 5,000 can't.
2,000 rupees to the bar association. Okay. And CRMP for the rest of to writ petition civil number 4357 of 2004. The order dated 23/7/2018 is recalled, and the writ petition is restored to its original file. Leave the matter for final disposal before the assigned bench. Yes.
Oblige, your lordship.
87.
May I play, my lord? 87. I am in virtual mode. I'm for the respondent. There is a compromise actually happening between the parties. So your lordship may disposed. Yes.
First, may I pray for restoration of the second appeal who has been dismissed.
Have you
Yes, compromise.
settled?
Yes.
Yes.
He says that
author, you have not signed the compromise.
no, I don't need. I can't do it here. I'll have to restore it in any case.
Yes.
But I just want to record.
Yes.
Record.
This is the compromise. My current friend has not signed for the respondent.
Delay? How much delay?
Delay is about 4 years.
For restoration.
Delay.
Yes, 4/9/20 and filed on 29/2 of 20.
Same or 20 for the and 2,000 rupees cost to same. I could do and the rest this is
RSA, yes.
RSA number 43
yes.
of 2017 is restored to its original file. The restoration is particularly ordered. The present petition is particularly allowed because Mr. Ratho, who entered appearance on behalf of the respondent on advance notice, joined with the counsel for the petitioner and submits that they have settled the dispute, and an application has already been prepared to be filed before the second appellate court for the purpose of disposal of the second appeal on the ground of settlement, on the ground of taking note of the same. The CRLMP is allowed, and RSA is restored to its original file. Means the RSA and the on date legal. I'll release it. I'll give a date so that on 6th or 7th, before the assigned bench, subject to permission of the chief.
How much cost?
Cost 2,000.
To the High Court bar association will find it.
Here I is fine. Yes. I have fixed the date, RSA date.
6th or
7th. 6th or 7th.
7th January.
Before assigned bench, you go. Yes.
Obliged.
Yes. 88.
That matter which would have, I've already finished my.
Yes, you morning you to say it.
Fine.
Very
I think
good.
the
I've already finished my submission.
The modification of order dated today is come. IA number 341.
No, modification. It's not hearing. Modification can list by astella.
No, সেটা তো
Push to before. Push to the.
13/1/2025.
Hmm?
This case was adjourned to 13.
For that modification, we listed it today.
13/1/2025.
But it was pushed because the complainant did not appear last time. Advocate for the complainant. I have finished my submission.
No, this matter has come only for preponement.
No. This matter was there to be closed. Your lordship had told, had posted it for final hearing
Title my lord, your lordship.
to close it.
The list my lord that is indicates that this case stands adjourned to 13/1/2025.
Stands adjourned because the informant did not appear that.
Thereafter, you move an application now.
I moved.
The application is there today.
That is the application.
That is the reason he is not there.
No, that is the reason I mentioned before your lordship. Because no adjournment was also sought for. He just did not appear. The day before that he appeared. He appeared and adjourned.
The application, the same is allowed. Date is preponed. Date of hearing is preponed to 4th. And in this matter, Mr. Subir Palit and Senior Counsel has already concluded his argument, and the counsel for the opposite party was supposed to reply. However, none appears for the counsel for the opposite party today. In the interest of justice, in the OP2, in the interest of justice, please the matter on 4th. Fourth. Third.
Third, let me indicate matter will be closed.
Yes, on that day, no adjournment shall be granted on that day. Yes. The order may be the same order, the office is directed to communicate the said order to land counsel for the opposite party.
Continue.
Entry want to continue. Yes.
89.
Settlement.
Passing of this proceeding.
498 है ना?
My lord.
Oh, I'll issue notice, huh? Issue notice. Yes.
90.
Here, my lord, the petitioners have challenged the order taking cognizance passed by the judicial magistrate first class G. Udayagiri, my lord, taking cognizance for the offences punishable under sections 498A and 494 of the Indian Penal Code, my lord. Here, the sole allegation.
Notice was issued?
Yes, my lord.
Anybody is appearing?
My lord is appearing and has also filed an application for vacation of stay. Here the case, my lord, must have remembered, my lord, that case with regards to Akshay Kumar Naik was disposed of by this honorable court where cognizance, order of cognizance was confirmed because he is the husband. And against that order, he has preferred SLP, which is still pending before the Honorable Apex Court. And the last order passed by the Honorable Apex Court was in the month of October, wherein, my lord, the counsel appearing for the respondent has taken time to have his say. The language of the Honorable Apex Court is the counsel would argue that the cognizance should not have taken order under section 498A IPC for a marriage which is over 3 decades old. Moreover, the offence under section 494 is non-cognizable. Paragraph 4, to receive appropriate instruction on the contention raised, the law and counsel appearing for the respondent, informant, within bracket informant, and the state counsel pray for and are granted 4 weeks time. After that, it has not been listed. But the facts of the case is, the state Akshay Naik, my lord, had married earlier. It is alleged but at the pendency of the first marriage, he got married to another lady, and the present petitioners have been taken as witnesses in that marriage certificate.
Second marriage. For which 498A, 494, and read with 109
cognizance has been taken. So with regards to,
Then the opposite party.
we are in no way
is the
connected.
Wife of the Kishore Kumar.
Okay.
Akshay Kumar, sorry, Akshay Kumar.
But we are in no way connected with Akshay Naik, so that we can be taken to be relations and can be taken as an accused.
Yes.
With regards to 494, if case will be accepted in toto, it's a non-court case, and that too law is very, it's a strict proof of marriage is necessary with regards to correspondence. How we will be in a position to know that Akshay Naik, for whom we are coming as witness, well, let me see the document.
Charge sheet filed?
Charge sheet filed, cognizance has been taken.
Okay, charge sheet filed. 494.
Let me see.
494 is not the problem. Problem is 109.
109. Valid.
It is alleged against you is 109.
494, 109.
For the purpose of 494, 109.
Abatement to commit the abatement.
For the yes, abatement to bigamy and all.
Bigamy. So, let me see this document.
You can't commit bigamy because only okay can do that. Nothing can be. You have evaded him. That's your allegation. That is the allegation.
My lord, if the case which is pending before the apex court will be quashed, for that reason, it has been adjourned thrice or 4 occasions. And my lord and friend, what prevented my lord and friend's client, the informant, who is a party there before the apex court, to pursue the case? And why, my lord, on the last occasion, I was present when Mr. Roy was, my associate was moving the application. And my submission of my learned senior friend was that maintenance application, DV applications, everything is pending because of this case. My lord, by a pass order that this maintenance application can move independently. That what connection?
Your entire allegation is Akshay Kumar.
The question is, the Honorable Apex Court has not, in its wisdom, has not decided to grant any stay.
That's a different story, but it is sub judice now. If qua Akshay Kumar, if charges are quashed, and the abatement, what abatement then?
That is what my submission is. Why should it be stayed? Why should it be stayed?
Because it is contingent.
No, the Supreme
because the outcome of SLP is contingent upon the fate of this case.
The grievance of my learned senior friend is that maintenance she's not getting.
I'll clarify that.
That may be clarified.
Pass in this order will not
stand on the way.
Stand in the way in so far as the other. Ideally, if something is sub judice before Supreme Court, why should I get into all this?
It is not the fifth case, first case should be granted.
And why they have taken time there in Supreme Court ballot thrice?
No. The entire allegation is against Akshay Kumar. If Akshay Kumar goes, then all these co-accused persons will also go. Under the aid of 109, you are trying to prosecute them.
Even if Malad twice it has come, then also the Honorable Supreme Court has not thought it fit to grant a stay.
No, every day. See, when notices are issued, every hearing, the Supreme Court will not keep on hearing bail application, stay application.
No, unless stay is granted, that means that Supreme Court has thought fit that it is not a fit case where stay should be granted.
I don't know whether stay was granted or not. How?
No, that is what the order itself shows that.
That's not. Ideally, see, some discipline has to be maintained. I'll clarify. I understand. Because of the stay of pass in this proceeding, maybe your maintenance and everything is coming in the way. I'll clarify that.
I am submitting a note, your lordship, and pass anyone. Because the previous case, this Honorable Court has held that prima facie case is there.
Against Akshay Naik.
Which case? Right. This court only might have taken the view. That is subject matter now.
That is subject.
If the Supreme Court takes the view otherwise, then obviously it has a direct impact on this.
Then, my lord, wasn't it their duty to see that stay is granted, stay is obtained from the Honorable Supreme Court?
Why are you not appearing in Supreme Court?
Appeared, my lord. Appeared has taken time twice to give their reply. My
You are
lord.
taking adjournment then.
My lord, the lord
You ask them to-
appearing for the informant and the state council pray for
Madam.
and granted 4 weeks time.
Where is your application? Modification? Application for modification, where is that? Recall, IA number 1213 of 2024. There लिखो. This court, while issuing notice in a petition, so this one go. The applicant in the present IA is the opposite party number 2, informant in FIR number so and so. Wherein the petitions are reduced.
The question is, they have been arraigned on the basis of 109. That your lordship can decide.
I'll decide it.
Petition. That was for the purpose, every purpose.
Petition, accurate.
Because
The petition, next one, the petitioners are seeking quashing of the entire criminal prosecution initiated against them by the opposite party number 2. The similar prayer was made by the co-accused of Sheikh Mark Naik before this court, which has been turned down by this court. The Akshay Kumar turned down by court by order dated 2/2/2023 in CRLMC number 2329 of 2021. The said co-accused Akshay Kumar Naik had approached the Honorable Supreme Court by filing SLP criminal D number 18666 of 2023, which is still pending. Taking into consideration this aspect of the matter, while order dated 9/4/2024, this court in the present petition has stayed the further proceeding in CT case number 186 of 2021 arising out of G Udayagiri PS case number 53 of 2021 pending in the court of JMFC G Udayagiri. The applicant, opposite party number 2 applicant has moved the present application for recalling of the stay order on the ground that because of the because of the operation of the stay order, it is her proceeding, the proceeding initiated by her for maintenance and DB proceeding also, DB proceeding,
I don't know, but 135.
maintenance proceeding
Proceeding out of.
and other proceedings are getting affected.
If any.
Affected.
why?
Counsel for the applicant opposite party very specifically submits that for disposal of her application of the opposite party under section 125 maintenance is he is not getting maintenance. At this stage I'm although by partly annual application, I am making it clear that the stay order passed by this court shall not stand in the way of the proceeding initiated by the opposite party before the court below under section 125 CRPC. Being a independent proceeding.
My submission would be, your lordship decide whether their case here is maintainable or not.
I'll decide it.
Just 1 minute, two lines. Even if supposing the Supreme Court allows, then that would go. But now they have been arraigned only on the basis of 109. So your lordship decide the case.
See 109. See 494. If that goes, 194 also goes.
That is dependent upon a future action.
No. Sure. Let us see, because see. Discipline is, if it is pending before Supreme Court, we should wait.
But Supreme Court.
What is the big hurry about it? I don't know. What is the big hurry about you?
No.
You want to send them to jail immediately?
No. If they are liable for.
The person who has created a problem for you, with whom you are married, or he is married to someone else, and you are not able to do anything to him.
If they are liable, nobody can stop them.
No, that's
if they are
right.
not liable, nobody
Simply
can
urgent.
impose them.
Simply And the interim order with this clarification, the interim order
You
shall
have
continue.
decided, CRLM.
I'll decide. Yes.
But director of the
Look. Soft good, file good. No, no, soft. I have only, I am going to hear it. I am clarified that the stay will not stand in your way so far as 125 proceeding is concerned. Maintain it independent proceeding.
Any other proceeding.
And any other proceeding, independent. If any other proceeding initiated by the opposite party against the petitioner or the co-accused Akshay Kumar. Because this is a different proceeding and those proceedings are different. The stay will not create any problem. Yes, next.
91. Disposal of case under section 133 said this for removal of encroachment for the public road. Now the opposite parties are piling up some materials. So there is no time limitation, time stipulation to carry out the order. So in this case, I have filed, the Lordship may fix a time so that the order shall be carried out.
I didn't follow you. Yes.
My lord, the CRLMC was allowed, 130 petition was allowed.
Yes.
On 29/4/2024, with a direction to the Sub-Divisional Magistrate Andhapur as well as Tahsildar to act upon the inquiry report. Because there is the encroached area which are to be, my lord, cleared out by the opposite parties.
Decide the application. Yes.
So, due to norms fixation of time, the order is not being carried out, and presently the opposite parties are piling up the materials.
What have what have you filed here?
Present miscase is
Miscase.
Fixation of, yes, fixation of
Timing.
Time.
And the earlier it was disposed of without time.
Without time.
That is what it
This
is.
is my prayer.
No, that is not the my lord order, your lordship answer.
The petition is allowed. The sub-divisional magistrate Anandpur is directed to decide the application.
The application, my lord, 133 application is pending for that court, my lord.
No, 133.
Your lordship is not directed to remove the.
No,
yes,
yes, 133.
Your line of the report may dispose of your lordship's like.
No, my lord, the State Council must assist to the court because public road is being blocked. So,
I am bringing the
page 28, page 28 of the brief. The enclosed person's names are there. Tahsildar submit a report before the SDM. Page 27.
Move the present application. IA number 3381 of 2024. Application seeking a direction from this court to the sub-divisional magistrate Anandpur to decide the pending application within a time frame. The criminal MC number 1090 of 2024 was already allowed by the order dated 29/4/2024 inter alia, making the final making the same direction. Para 2. The counsel for the petition submits that although there was a direction for disposal of the application, however, there is no time fixed for the proposal for the same. Hence, he seeks indulgence of this court. Regarding head to the aforementioned, it is how much time?
Because the road is blocked, everything is spot visit.
How much time you want? You tell me.
2 weeks.
2 weeks, it can't be possible. If you want shorter time, then I have to issue notice. Behind their back, you can't take the order.
No.
That's
enclosed persons.
I don't know what
133 proceeding lawsuits.
133.
But then I'll have to issue notice to all the respondents. Behind their back, I can't pass an order like this. If it is reasonably longer period, one can.
I pray.
Yes, I'll pass the order. Yes.
SDM should dispose of the application.
Yes.
Time.
I'll do that. Yes.
May I please the lord. My lord, this matter has limited time as this matter.
3 months.
Put some high claims. There is a matter, my lord. The shop was unlocked by the opposite party. Shop was unlocked, and the buyers are facing a lot of problem. That is 92. This unlock has given direct notice to opposite party. Shop to police shop. Despite that,
service is complete.
There was a direction to unlock the shop by the
OP3 ta ko hai nahi. OP3 with postal address is left, hence returned to sender.
That's why through police. That's why your lordship was directed to serve the notice to local.
No, wait,
Did not.
Okay, IIC.
There was a last order, last time your lordship.
Pursuant to the order is not to notice, opposite party number 2 is heard, huh? Opposite party number 2 is heard. What about what about opposite party number 3? 3 देखो 3 का 2 is heard.
Addressee hence return the sender.
The address he left 3.
Therefore, your lordship, last order, your lordship was directed local police to call service of the notice.
No, last order is only release the matter on 23rd 12. Last order, there is no order.
No, before that, that's why last time you have taken
See,
time.
before that, I'll tell you. Before that, the order is 7/10/2024. Not before that, the other day. That direction was to serve the opposite party number 2 through IIC.
Yes,
There is nothing about opposite party number 3.
Yes, that's why it taken time to take instruction whether the police are there.
Yes. Opposite party number 2 is served.
That's subsidy. Who your lordship?
I'm talking about 3.
Three your lordship is not directed for 2.
The insofar as the opposite party number 3 is concerned, the notice could not be served as the postal endorsement indicates that the address invited the addressee left. Therefore, the IIC Kendrapada Town Police Station, Kendrapada
Town PS.
Kendrapada Police Station, Town Police Station is directed to serve opposite party number 3 and report serve opposite party number 3. Leave the matter also. None appears for opposite party number 3. Second week.
Number 3, the Prokuma opposite party. Actually, order was.
Unless you drop it, I can't help it. Yes.
In item 66, I was absent. I have gone in drinking water. I was in item 42.
66. I have allowed it. If you want me, I'll recall that. No, I have recorded here.
I
record it. Yes. Yes.
Made please, Lordship. It's a dispose of material, Lordship.
93?
Yes, Lordship. It was disposed of on 8/11/2024.
93 ର ସେ certificate ବି ଦେଇ ନଥିଲେ ସେଟାକୁ ଟ୍ୟାଗ କରିବା ପାଇଁ ସେ ଫାଇଲ but that has been disposed.
It's a
Disposer.
Yes, Lord.
I'll allow the IE. For the reason stated in the application, the IE is allowed.
Obliged.
Yes.
94. May please be. Instruction was called for whether appeal has been filed or not, madam. Say 94. The bank release kariba.
That is service. Requisite you have not filed.
No, but he's not necessary. But bank tackle party courage, but instruction was called for, my lord.
No, last order just see. Issue notice to opposite party number 3.
Requisite not filed.
Requisite not filed.
Instruction has
On 25/11/2024.
Instruction was called for, appeal has not been filed.
Issued to opposite party number 3. However, the petitioner has not filed requisite by a last time. 1 week time is granted for filing requisite. Please the matter. 3rd week. Third, 4th week. March.
Yes, a modification of order, my lord. Order 3/12/2024, my lord. Matter.
3/12/2024.
In fact, on that day, matter was settled. But in that case, lordship directed to examine the victim's principal witnesses and victim guard. But in the meantime, that they have been examined. Re-examined lekha gala se khali heju. So examined lekha heju. Also, I have taken my plea in the main petition.
Which paragraph you want?
Paragraph, my lord. Paragraph, my lord.
This your lordship, that the paragraph 9 your lordship, from the bottom, 4 lines. The learning counts trial court is directed to do well to see that the principles of witness, the principal witness, namely the victim and mother of the victims, are examined preferably over all other witnesses. Your lordship. That your lordship re-examined, your lordship, my lord, this paragraph says.
Re-examined.
Re-examined.
Se examine he thila agul. In the meantime, matter has settled. And thereafter.
Re-examined means then you would move application 311. How can I do like this?
Otherwise, liberty to.
No. You move application. Who stopped you? You have actually by way of this application, you are trying to, move on get relief under 311.
No. 311, I'll file.
You file it.
I'll liberty.
Let the counsel for the petition seeks to withdraw this application to file appropriate application under section 311. If such application is moved, same shall be considered on its own merit.
Within liberty.
Clear that this court has not taken opinion.
Within liberty to file 311.
I have said that you move application. You only made the statement that they are to be examined. I wrote it. Anyway.
96.
May I please, madam? Your lordship on dated 3/8/24, your lordship has been directed me to implead the injured as parties. In that regard, I have filed an IA bearing number 3440 of 2024 on today, madam.
Release the matter.
To implead the injured as parties.
Okay. That application is not here.
They are not here.
It hasn't come. Simply urgent. Huh? Simply. Yes, next.
97.
97.
Notice to go, my lord.
Application is not there. How can I? What can I do? You file that application has to come. Yes.
Modification of order. I have wrong. Inadvertently mentioned the date of NBW 6/12/23 instead of 22/5/15, my lord. 22/5/15.
In the prayer, just see what have you written.
Prayer of IA.
Main petition prayer. Main petition prayer. Page 4. What have you written?
6/12/23.
So,
but this is the split of case. And then
whatever you have written, the same thing I have written.
Yes, I have filed certificate copy of NBW about in IA case. IA case re mo certificate copy ta file korchi.
Kete cost itla hai?
And pending in the court of STJM Bhanjanagar.
STJM court. ठीक है.
Time may be extended, man. Time may be
extended.
Oblige.
In this kind of thing, I should start imposing costs. Whatever you want to write, you are writing. Accordingly, our work is getting increased. Yes, next.
98.
Rest of the matter you have to do. कितना matter है? कितने जाए पहुंच दिला में 100. All wherever interim orders are there, it will continue. Interim orders are there, it will continue. Any very urgent matter.
Item 99, modification of order.
One after another.
Yeah, let's.
One after.
128. Pilot must have remembered that England's case where around 50 adjournments, cognizance was taken and
that matter.
And the co-accused, the person.
I'll keep it on third then.
So, what they have done, the court has done, issued warrant of arrest because they are not in a position to move. 91 years old.
Oh, show me. I'll stay the warrant.
Well, I have filed it. I have filed the miss case.
128.
1151 of 2024.
128.
Order dated 26/11/55. Warrant of arrest.
No, where is that? IA number 1073.
No, IA number 1151.
It is there.
No,
it's not scanned. What to do?
Scan. Scanning. Well, whatever. That case is listed in the list.
You get it scanned as state. Right on. For the reason 1151, there is 128. For the reason of the application, the order, the execution of order dated Order dated 26/11/2024, the state till next date of hearing. इसको correction कर दो.
Only execution of warrant and.
Execution of warrant, I have stated.
And my lord has already.
You have, just see this matter.
By the hearing, in one case, wait a minute. In one case, the hearing has been closed.
This case, Mr. Marana, what had happened is 2003 FIR. Investigation and closure report filed.
A final report was filed.
And it was pending. Adjourn, notice was issued to
Around 60 years.
complainant. After 60 years adjournment, he didn't come. Thereafter, another magistrate comes and take cognizance on that. There is no this thing. How can you do like this? 2003, and these people are 90 years and all. 84. What is this? I would have quashed it straight away. I gave an opportunity.
Mr. Das had taken it.
I have stated that. I stated that.
My lord, on the last occasion also directed me to prepare a short note of submission. I prepared it referring the judgments.
I'll keep it immediately application and state. Yes. So they didn't so that he can. He will not be adjourned at least. Next. Yes.
99.
Yes. What do you want? He will adjust the date. I can't wait for some time. It may be adjusted for thought. Let us see. Wait.
27, 120.
No, sir. 98, 99.
99 minor mill.
Modification.
Modification mill.
Both the modification allowed.
98 is the not modification, Lordship.
What do you want?
Lordship, in this case, Lordship, last occasion, I have challenging against FIR, Lordship. But last occasion, my
98 adjourn कर दियो, 99 allowed.
I may pardon, my lord. Item number 116, my lord. There is an interim order, my lord, but the IA has been disposed of. I have filed a new IA, that is 27285/2024. Kindly maybe extended that interim order till
116.
Again.
Earlier the stay was there.
Sila kintu IA talani dispose of page. So therefore, I would IA file till the disposal of CR.
I stands dispose of.
My lord.
No, for 6 weeks it was supposed to be.
My lord. 6 weeks.
Okay.
Item number 127.
Yes, sir.
Adjourn matter already 3 times not reached in list.
What can I do?
Sir, when sir trial started, you all sir stay with issue.
What do you want now?
Sir, I want to hear that matter, sir. Next, sir. Tomorrow, sir, at least.
I have some work, therefore I am going. Otherwise, I would have said till 7 o'clock. There is some urgent work.
Sir, my lord,
not possible.
My lord,
Tomorrow, at least, sir.
my lord, item 98, Lordship.
He will adjust the date.
Lordship, item 98, sorry to interrupt, Lordship. Lordship, in this case, all the co-accused person granted bail by this honorable court, Lordship. Lordship, last occasion, adjourn only, I am not annexed some of the co-accused bail application, Lordship. I want only parity, Lordship, kindly taken up tomorrow, Lordship.
Tomorrow, I am not sure.
122.
109. Then challenging JB proceeding, my lord. Lordship only say, my lord, any adjournment for some side, my lord.
Who are you? Your husband?
In-laws, my lord. Mother-in-law, mother-in-law.
No, if there is a maintenance order and all, that staying is very dangerous.
No staying, my lord. Only your lordship passed order, my lord. Any adjournment, petition files and something.
Mediation is there. Mediation report is awaiting. Oh, right.
122.
Mediation awaited लिखा है.
109. 109.
Mediation awaited लिखा है. 109. Mediation field, yes. Mediation.
In the morning, somebody mentioned the argument.
Somebody has mentioned it. I can't pass the order. But the opposite side was there. He was mentioning it. Behind his back, I can't pass any order like that.
120.
Lordship has passed order. That any adjournment petition filed, then
That itself is an order. The other side has to be there. On the morning he mentioned it. I can't do it. Yes, sir.
My lord, 122. In a DA case, the housewife has been arraigned under section 109.
Yes.
Your lordship had granted time, he wanted to take instructions. His Sonolata, your lordship has passed judgment.
But that is in a different line altogether. We'll see.
A date
Check
will
it.
be fixed.
Date will be fixed.
Tomorrow it can be decided. Because I have nothing to argue, I have already argued the matter. Only pure housewife. And she has been arraigned only section and DA case.
We'll see that. What
Alias
can be done.
One-
He will adjust the date and give. Huh?
130 item, 130 item, the lordship already had some way, and the lordship directed this vigilance to take instruction, and my request, my lord, my friend has already, only it will take.
Likely to?
5 minutes, it will take 5 minutes. It's a poor.
He is saying likely to be allowed to wait before he changes his mind.
Hardening part, he also already had. So that is why I am saying, also the hardening part, so that.
If he
disposed.
hard in part 130. He says that it's
Yes, yes.
likely to be allowed.
Yes, yes.
Then
I
you have a
detailed
good
all
case.
this.
My lord, 108 entry order may continue and it may.
Entry order will
My
continue.
lord, January, any date may.
January he will give January. Okay. Thank you. Thank you.